Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, we got my good friend David deRubertis here today. David and I would go back not too long, maybe about 6 years. David came to a Trojan horse workshop that I was teaching in Orange County. I remember when he registered, because I didn't know David at the time, but I'd only heard of him. And so I was like, wow, this big-time lawyer is going to come to my little workshop. This is exciting. And so, but that just, honestly is just evidence of, the kind of lawyer David is, because, even though, let's just say I was much more up and coming back then. But still he was coming to learn and get better. And I got a chance to work with him on some cases before and, do some case analysis with him. So I get an idea how his mind works, which is hard to figure out. But it works quite well when it comes to figuring out the trial stories. And so I'm glad David's here today to talk about a few things, which are, his upcoming trial college master class that he's doing in Huntington Beach, June 7th and 8th. A couple cases that he had some great results on last year that are going to be the focus of those master classes. And also we got a couple case analysis webinars scheduled on those particular trials so we can take a deep dive on them. We also have a combination case framing class presentation skills boot camp that we're going to do here in Vegas at my place right here, if you can see it in the background. Well, the other side will be done by then, so we'll have 2 great training facilities for about 10 people to come work on their employment cases with, David helping them frame the story and myself and my other coaches helping them to get up and present and tell the story, because there's two different very important aspects of it. And so that's kind of the layout of the program. So David deRubertis, trial lawyer. How's your day going this morning, Mr. David deRubertis?
So far, so good. The kids did not fight on the way to school, which is the barometer of success in my mornings.
Starting off great. Good. So, David, before we get into all the classes you're going to teach and the other, the webinars and the combo boot camp, first, when did you know that you wanted to become a lawyer?
It's a good question, Dan, because as far back as I can remember, I wanted to be a trial lawyer. What we cannot figure out, we being my parents and me and my family, is where the heck it came from. We have no lawyers in our family. We have no friends who are lawyers. There was a total void of lawyers in my life as a child. But I have memories literally from grade school about wanting to be a trial lawyer, and very specifically a medical malpractice trial lawyer. So just as long as I remember in grade school when writing fictional stories about trials. I remember as a young kid, I would literally, in my room, pretend cross-examination. No idea where it came from. I remember as a kid reading Paul Newman's The Verdict book and the Perry Mason books, but literally no idea where it came from. I was the kid whose aunt bought him a briefcase as a young child because everyone knew I wanted to be a lawyer. But the mystery is where the hell did it come from? We can't figure it out.
So you had this burning desire to be a lawyer, but unlike most people that get these ideas or desires, they wait until adulthood to act on them. But that wasn't quite the case with you. So what was your earliest actions that you took that helped you arrive to, honestly, where you are today?
Yeah, so I have a very unique and lucky path, frankly. Very lucky path, helped by others. When I was 15 years old, after the summer of my sophomore year in high school, I was a volleyball player in high school. And those of you who know me know that I'm 5'6" on a good day. And that sophomore year of high school, that summer after the sophomore year of high school, it's time to go to varsity volleyball or not. And I played beach volleyball all summer long that year. And my height became an increasing obvious impediment to success as a volleyball player. Because, by the way, the short people in volleyball, they're the setters. I sucked at setting. They tried to make me a setter. It didn't work. So after that summer of sophomore year of high school, I gave up the ambitions of competitive sports. And I actually sat down with my mom or dad, or my mom actually, and wrote up a resume. And those of you that know Los Angeles might know the San Fernando Valley, and if you know the San Fernando Valley, you know Ventura Boulevard. That's that, especially back then. That's where in the San Fernando Valley all the businesses were. So at 15 years old, I walked up and down Ventura Boulevard basically in 1990, handing off resumes to every law firm that I could find. And one of those firms, I just happened to strike gold. It was a medical malpractice plaintiff firm, McCulloch and DeMontesquieu. Paul DeMontesquieu was the well. Let me go back. So I interviewed at the time with the office manager, and she was had worked with the firm forever. She ran the show basically, and I'll never forget. She's just sitting there looking at this 15-year-old kid with this little resume, saying, "I want to be a trial lawyer." She pinches my cheeks, hires me on, and is like, "You're so cute. I'm hiring you on the spot. Can you?" And she's like, "When can you start?" I'm like, "When would you like?" And she's like, "Right now." And I'm like, "Okay, I can start right now. Do you mind if I go tell my mom, who's in the car downstairs waiting for me?" Which made her even think it was more adorable. So I'll never forget. I can actually tell you the exact day because it was July 3, 1990. And the reason I know that is nobody told me you don't have to come to work on July 4th. So I actually showed up on the 4th of July to work that day. Of course, at a busy law firm, there was someone working, and I put in a full day on July 4th where we didn't, like, my parents and I didn't know if I was supposed to. So, but I was just really, really lucky and really, really grateful for the opportunity because at the time, Paul DeMontesquieu, who both Bob and Paul, the two partners, both tried cases. Both were, plaintiff medical malpractice and, 80% med mal, 20% other stuff in, injury cases or some random stuff here and there. But Paul at the time, who unfortunately has since passed away, Paul was going through a divorce at the time. And, people that have gone through that know how tough it is. And you can be lonely at times. So Paul was working all night, all around the clock, always at the office, and took this liking to this young kid who just wanted to learn. So over the next, from high school through college, I worked, long, long hours, at this firm. It started off as like a file clerk, basically, and I'll never forget every piece of mail that came in that was interesting or substantive. Now you probably can't. I probably violated all sorts of rules in retrospect, but that I didn't know about. But I would make a photocopy of every single substantive piece of mail, and I would take it home and I would read it every night, basically, to learn. And by the time I was in college, I was writing their legal briefs, and the real fun part, I was attending, sitting at counsel table every trial with DeMontesquieu. So I was working around the clock, kind of blowing off school, paying people, my sister at times, friends at school to go take notes in classes for me at UCLA, as I was spending most of the time working. And I think I haven't counted it up, but I went through something like 10 to 15 jury trials, sitting at counsel table, the second chair who can't speak because he doesn't have a license, basically. But it was just an amazing background to an opportunity, and I'm so grateful for that chance because it really showed me a lot, at a stage when most people have no idea what this stuff's about.
And most people have no idea what stuff about even after they go to law school, even when they start practicing, because most people just take a job wherever they can find one because they got bills to pay. But let me ask about your choice of law schools. Where did you, after UCLA and not attending and having people take notes for you and doing as little as possible to get through, where did you end up at law school?
So I knew I wanted to be a trial lawyer, and I knew I was going to practice in Los Angeles. I had, by the time law school started, I had 7 years of connections in the legal community. I wasn't going to leave LA. So, I applied all around. The ego at times made me think of going to some of these really prestigious schools, but I'm so grateful. I think I made the right choice, which is I blew off the great schools, the supposedly great schools, the ranking
Where else
wise.
did you get accepted besides the one you chose?
Most everywhere. I didn't get into Harvard or Yale, but I think I got into pretty much everything
Okay.
else. And I chose Loyola. And I chose Loyola because Loyola Los Angeles, because I think it's got the, even back then, and it's gotten even better over the years, but it just has the most phenomenal practical trial lawyer training. We had our burn mock trial team, which is a, very hardcore, intensive, nationally ranked program. Loyola at the time, and it's still the case, I imagine, offered more opportunity for actual externships, trial related work than anywhere else. So after that first year where you do the mandatory stuff, the second and third year, we spent more time in, I spent as much time in externships in courtrooms almost as in class. You could, did hundreds of preliminary hearings in criminal cases. But, one semester I did juvenile criminal prosecution through the DA's office, where I did, 15 bench trials. It was just an amazing, amazing, amazing practical experience. Everything you hear about law school, about how much it doesn't train you to be a trial lawyer, Loyola to me was the opposite. It just, the percentage of time focused on stuff that would actually matter as a trial lawyer was tremendous. So that's what I did.
It makes me think back of my own law school in Detroit, and like there was none of that. Or maybe there was, I just didn't give a shit about it because I didn't know what I wanted to do, and I was just getting through school to get through school. But last night, this young kid was over. His name's Luke. He's coming to TLU Huntington Beach because he works for a buddy of mine who's a criminal guy. And we were working on his case last night. And this Luke starting law school at the University of Illinois in September or August. And I'm so stoked for him because last night we were talking about putting together a plan for him to become a trial lawyer, but start learning the fundamental skills now. So we did some of the physical skills training last night and talked about the TLU on demand, and because you gotta learn the physical skills of presentation. The better you get at presenting, the more successful you're going to be. But you also got to learn all the trial strategy stuff, because there's so much to learn on the case framing, sequencing of witnesses, what visuals to, all this stuff. But then there's also, which I'm really excited for him, is that he's coming to the conference, is to come to these conferences and meet these great trial lawyers and get a network of people who have figured this shit out. Who, when you're friends with them, and you have a personal relationship, it's a lot easier for them to take your phone calls. And so, I'm just thinking back about like your journey, but if we can try to, like that you had this instinct to do it as a young kid, but help other young folks who want to be trial lawyers, but it's really not hard to figure out, to help kind of give them some guidance along those directions and see what happens with them,
And now, the beauty of nowadays is, back when I did this, this is my almost approaching 25th year. I got out of law school in 2000. Nobody was throwing up their own shingle in 2000. The resources and the connectivity was not there within, when we needed to reach out to people, it was phone calls to the office. It wasn't text messages. It wasn't listservs. Nowadays, and with your community you've created and the other communities out there and the connectivity, I think it's a lot easier to do this early on in career. And I think newer lawyers that want to forge a path of trial work, the opportunities are there now, because if you get your name out there and you start showing you can do it a little bit, word spreads in a faster way than it used to. So I would definitely encourage everybody, find that path that lets you to try cases earlier rather than later in your career.
And be surrounded by people who are trying cases, who will let you come and sit in, maybe on some prep sessions, let you hang out, carry briefcases, whatever you got to do to be in the mix. And in today's world, like there's so much opportunity to get all the knowledge, not only the strategic knowledge, but if you want to build your firm, like at TLU Huntington Beach, there's Steve DeBosier and Chad Dudley are teaching a 2-day operations business optimization masterclass on Wednesday and Thursday. And they have this huge firm down in Louisiana with about 50 lawyers and a couple hundred staff. So they really know how to, build a big practice if that's what people want, or an efficient practice. And then on Friday and Saturday, Daryl Isaacs and Rob Levine are teaching a 2-day class on the business operations. And I just bring that up because stuff like that wasn't even thought of or conceived of a few years ago. Like, how do you run a practice? What do you do to get started? I mean, for folks, because you, when you got out of law school, tell us what your decisions were as far as, your starting out your career, day one, because day one makes a big difference. What people do day one, People go to the defense and take that, big fat paycheck, but those 60, 70-hour weeks or 80-hour weeks and, kind of get hooked onto that money and the security of it all. But tell us about your choices and path when you got out of law school.
So my path was a path of indecision, and by that I mean I had realized in law school I got really into employment law. I still loved the malpractice and the other stuff, but I was really stimulated by the interesting development of law in employment law. It was super in flux and super changing, and I found that kind of the combination of the interesting fact patterns and the super developing law to be kind of what I was most into. So I decided I wanted to be an employment lawyer, and the place to go on as the new lawyer coming out of law school who wants to be trained as an employment lawyer. The cream of the crop was Paul Hastings. They had, and I think still have, if not the premier employment defense practice that there is. So I did fine at Loyola and was going through the interviewing process and had narrowed it down and had actually accepted a summer clerkship to start as a corporate employment defense lawyer, summer at Paul Hastings. And look, I came from, very, modest means. My parents, are hardworking, middle class people that never was excess part of our life. Even if you had it, you didn't spend it. We were raised, my dad was World War II, in Italy type of person.
Depression,
And
scarcity.
exactly.
Don't spend $1 you don't need to spend.
Exactly. So the idea that, I would have that, in 2006 figure starting salary was appealing. So I had accepted this summer position, and my thought was, look, I'll spend 2, 3 years, 4 years maybe at Paul Hastings, and then I'll open up my own office. I had saved a lot of money up for opening my own office all those years working, and then there was a relationship I had in law school where the two of us had different ideas of spending, and I went from like $70,000 in the bank to basically $50,000 of credit card debt and less than $10,000 in the bank. So I wasn't in a very good position to open up the office at that point. So I was going to accept this position at Paul Hastings. I accepted it. After I accepted it, the truth is the decision was eating on me, and it just weighed on me. And it was two things. Number one, I'm not philosophically aligned with defending corporations who do bad things. That was a struggle. And number two, as a practical matter, I wanted to be a trial lawyer. And I had sat at counsel table watching others try cases for like approaching 10 years now. I wanted to be able to do it myself. That wasn't going to happen at Paul Hastings either. So I struggled on this decision. My parents think I'm insane for considering not doing it. They're trying to talk me out of it, like, go work a few years, save the money, and then open up your own practice. The week before I was supposed to start, they had already taken my picture. I had an office. I had a nameplate. I was in the summer associate handbook. My photo was. And the week before, I called up. Jim Zapp was the Paul Hastings person who was doing the recruiting, and he actually tried some cases. So, he was trying to let me know, look, there are trials here sometimes. I called him up and I said, Jim, I just can't do it. My heart is not in it. I'm a plaintiff lawyer. I have to thank you and apologize and say I can't do this. And I'll never forget the conversation of what a mistake I was making. Now, the year before that, I had worked over the summer for a plaintiff lawyer, Steve Rotman, who was a very top-notch plaintiff employment lawyer. I actually met Steve when I worked for the Med Mal lawyers because Steve was a brand new lawyer at a big firm defending an employment case that we had. So after the first year of law school, I worked for Steve. I had negotiated. Now, Steve wanted to keep me and wanted me to work for him after law school. So I eventually was negotiating with Steve to match the Paul Hastings offer. So he agreed to match it, and I was going to start off, I was going to summer the second year of law school, summer with Rotman. And then after law school completed, I was going to work for him. Well, guess what? Even though he agreed to match the Paul Hastings offer, I summered for him that next summer. I've now summered for him 2 summers in a row. No trials went out. And I was on the right side, but still we weren't trying cases. And as I got done with law school and I was deciding what to do, I had the heart-to-heart with Steve of, hey, Steve, that conversation I have with Paul Hastings that I just can't do it? Yeah, I'm having that same conversation with you. I need to get out there and I need to try cases first chair and talk to juries, and it ain't going to happen. So I ended up flaking on Paul Hastings. I flaked on Rotman, and then, right after, basically as right after the bar was done being taken, or right when I was done taking the bar, I rented out an office from one of the partners I had worked for years ago. My office was it was literally the size of a closet. My mother, who's the nicest person in the world, made fun of it. She really did. My mom's like, you can't even change your mind in that closet. It was that small. It was just a horrible workspace. It was, you're trying to get from one part to the other. You're banging the doors, but it was cheap. It was essentially free, and I worked, so I opened up my own office. I had literally, I don't know, I think $2,000-$3,000 in the bank at that point. But I had spent so long working for lawyers that the second I was sworn in, I had 40 to 50 files already to handle in co-counseling with them. So that's sort of the long version of how I started.
All right. Well, it was an aggressive start, but how long until you got to trial with your first jury trial after you got your bar card?
So that's the cool part, Dan.
Well, thank God I asked this question, David.
Yeah. I tried my first case as first chair 2 months after getting sworn in, which even by years ago that happened. By 2000, that wasn't happening. That first year in practice, I tried like 6 little cases, and they were, rear end fender bender car crashes with a couple $1,000s in Cairo bills. They were those kinds of cases. But I tried like 6 of those the first year to year, like 14 months. I did like 2 or 3 good binding arbitrations. So it was great, Those cases, I basically went out and let all of the larger volume PI firms that I could get connected to know I will try anything. And it was the classic story where on Thursday they'd send me a file, and on Monday we're starting trial. So I did that as much as I could, and then I handled cases that could maybe make some income to fund the trials that were not, those weren't income producers. Those were just experience.
Before we talk about what we're going to teach in Huntington Beach, I said, what's your first big memorable verdict where it was like, hey, this is what I'm meant for. This verdict right here.
It's funny. I can't give you one answer to one case to that. I can give you different cases at different points in my career that were so memorable. In the very early days, it's kind of hilarious. I remember a $10,500 soft tissue verdict in Norwalk that felt amazing. It was a horrible defense lawyer, no real offer on the case, super tough case, and got like $8,000 in emotional distress in a soft tissue case at a time where they were coming in defense, $0, $0, and I was on cloud 9. Now, going further than that, the kind of one of the pivotal moments, and this was just something I assisted on, and I wasn't first chairing this in any way, shape, or form. This was his deal that he asked me to assist on. I got really lucky as I was trying these kind of small PI cases, and the value was going up. I remember hitting one for 60,000, and then finally the first low 6-figure. They were I was incrementally increasing the caliber of the cases on the PI side, but I was getting frustrated because my employment cases were settling and they weren't going to trial. And then a wonderful mentor and friend, Chris Whelan up in Sacramento, who's an outstanding plaintiff employment lawyer, trial lawyer, one of the best in California, one of the handful back at this time that was trying these cases in and out, asked me to help out on a case of his that was going to trial. And it just goes to show how you never know that moment that's going to change your career. I had just given a speech at our California Employment Lawyer Conference about disability discrimination and medical leave cases. It was an area that I realized at that point in the early 2000s, plaintiff employment lawyers did not know those two areas. They knew most kinds of cases. They didn't get medical leave or disability cases. So I focused on those a lot, and I gave this presentation. And a few months after that presentation, I got a call one day from Chris saying, "Hey," and those of you that know Chris's voice, "Hey, David, this is Chris Whelan from Gold River." I can't do his voice, but this really deep, booming voice. "I got this case that I think's a really good one that I'm wondering if you could help me out a little bit because I'm not really following all of this medical leave disability law, and it's going to trial in a couple of weeks up in Yolo County." So long story short, he invites me to help out, and Chris tries, I kind of keep him on the straight and narrow on the law and making sure the facts are fitting the law. And he goes and tries this case, and it hits for 19 million in Yolo County, which was the largest employment verdict of the year at that point in time, and the largest disability and medical leave case in California history. And this was in 2004. It was before, big 8-figure verdicts were common. They were, there'd be one of these a year, if that. So that was a big pivotal moment. And look, then I can tell you other cases, but those were sort of the early days that kind of really showed me how there's a progression in this, if that makes sense. My path to success was not, early overnight. It was starting at the bottom and kind of working yourself up. And then that was Chris's trial, Then my next trial was a super small, my next one, which was the first. Well, no, I did another one with Chris, and then I get into starting to first chair employment trials. And frankly, that put me back at the bottom again, trying very small, tough cases. And it took a good 5 to 10 years then to get to the point where, I'm getting the kind of results that happen for me later in career, if that makes sense.
That does make sense. All right, well, let's talk about this class that you're going to be teaching June 7th and 8th in Huntington Beach. Now, last year, you did a 2-day master class on employment that was very well received. I think there's about 30 people there live, and it was recorded, and so it's been on TLU on demand. And so, anybody that, part of it has access to it and the teachings, whether they were able to show up or not. But tell us how this class that you're teaching this year is going to be different than what you taught last year.
Sure. And so last year, my good friend and colleague Brennan Kahn and I did the program, and we did that program based on our Edison verdict that we got in 2022, which we tried together. That program, look, there's some overlap because some of the things I'm going to talk about in this program are improvements that I've made in my own methods that are sort of central. But it's primarily a very different program. The last program, we spent a lot more time on the kind of workup of the case and development. This is going to be trial and trial only. It's going to start off with, and to me, I think one of the major reasons I've had the post-pandemic success I've had, and I owe this to you in large part, Dan, is during the pandemic, I finally slowed down and I started actually spending time thinking, and I started forcing myself to not work all the moment in terms of doing, and I started carving out thought time. And the thought time really focused to me on figuring out through my own trial history, in my own career, why is it some cases at trial turned out how I wanted them to, and others were disappointments? And to me, the ultimate big difference was, you kind of get better at knowing a good case than a bad case with time. But beyond that, in employment cases, I believe, at least the way I try cases, the structuring and the framing of the story, is 80% of everything. There are so many choices to make in employment cases of what story is told. Most fact patterns lend themselves to 10 causes of action. Most fact patterns have all these turning points. So anytime I talk about trial, you're going to have to listen to me talk about framing and structuring and sequencing the trial. And I'm going to do that this time in the context of the two employment cases I tried last year. And what I'm really excited about is they're completely different. So you're going to see not just framing and structuring through one fact pattern, but through two totally different fact patterns that we'll talk about. One of these cases was a classic failure to accommodate case with some very big challenges on how do we get punitive damages. Another was a case that involved every claim imaginable that we pared down to be a very streamlined retaliation case. So we're going to talk about the framing of both of them. I'm going to spend some segments in this session that on one topic we didn't get to last time, and we just had to skip, which I think is one of the most important skills a plaintiff employment lawyer, trial lawyer has to have, which is storytelling through adverse witnesses. I'm going to spend one, if not two segments going through my, adverse examinations in California at 776 exams, and to show you how you can win employment cases when you have literally no favorable witnesses. When every witness other than your client you're putting on the stand is a negative witness, the adverse side's witness. And not just the theory of it, but actually showing through some of the exams I did in the two trials we'll talk about, how you construct your outline, how you construct your logical points, how you use what I call the controls of a witness, which is the document is my first choice, the deposition, concession, my second choice, or common sense as the third choice, the witness controls. So we'll show how to use those witness controls where you can tell the story through adverse witnesses. I'm also going to cover topics that I struggled with in these cases. One great example is in the Marriott case that we'll talk about in a little bit. How do you get punitive damages when you don't have a bad actor testifying at trial? The bad actors in that case, the decisions made in that case were made by sort of higher ups who were not available and did not testify and were not deposed. So how you can focus on corporate culture issues that get you around the problem we often have in California, which is when you're suing a big company, how do you get punitive damages when only lower level actors acted? There's no managing agent. So we'll cover those things. We'll cover also, jury selection, the changes I've made. There's a lot more, but what else you want to know, Dan?
Well, let's talk about each one of these cases. So give us a snapshot so that we have context for the two different cases that you'll be teaching on, because those two different cases too, we're going to be doing webinars on those this summer, and we're also going to be using those as the context for discussing trial in the rest of the podcast. So let's talk about the Marriott case first. Give us the laydown of that case.
So the Marriott case was a failure to accommodate disability case against we were representing Dan Callahan. Dan was a 30-year concierge at the San Francisco Marquis Marriott. Now, Dan was truly exactly everything you would think about as a concierge. A great guy, but he had a lot of challenges in his life. And he's worked for Marriott at the 25-year mark. Everything was great with his career. He was loved. He did the job well. But Dan struggled with chronic back issues for lots of reasons. But eventually, he was getting epidural treatments for his back, and an epidural went bad. And he woke up as a walking or incomplete paraplegic. He was told at that time that most likely he'd never be able to get back to work. Dan, who had a young daughter, wasn't accepting that answer, and he just did everything he could do to rehab. After about a year of rehab, he was able to come back to work. And he had a series of restrictions. He needed to not walk too far. He needed to be able to alternate sitting and standing depending on how his body felt. He needed to be able to have a break room that was closer and a bunch of other things like that. The long story short of the case is for 4 years after he returned, Marriott wasn't perfect, but they did a lot of things to accommodate him. They adjusted his work. They provided like risers and things like that on the workstation to ergonomically make it better. Let him use the employee restroom rather than walking to the far away. To the guest restroom rather than walking to the far away employee restroom. They allowed him to park at the valet place and walk in through the customer entrance rather than the employee entrance. They did, a bunch of different anti-fatigue mats. So they did all these things for him. It wasn't perfect, but it also wasn't horrific in those 4 years. Now we come to January 2019. The Marriott had undergone a, almost hotel-wide $150 million renovation. And that renovation included new workstations for the front desk and concierge employees. Now, historically at this hotel, for the entire time Dan had worked there, the front desk folks had one type of desk and workstation. The concierge had another. The difference was the concierge, who were often working for hours at the computer, booking reservations, making phone calls, they had a desk which had leg space that you could put your feet underneath and your legs underneath like a normal desk. The new workstation was different. The new workstation was a block of, it was a big towering like stand-up workstation that on the side where the concierge worked, there was no place to put your legs if you were going to sit down. It was a bank of drawers. So Dan tried to sit at this workstation. He's literally gouging his knees, against the drawer handles, basically. Long story short is from January 2019 until September 2019, there was a massive, back and forth to try to get that workstation properly, accommodatable, and they just wouldn't do it. And by September 2019, Dan decided, my body can't take it anymore. It's causing me too much pain. You don't want someone with a chronic pain condition to just be in massive, massive unnecessary pain that causes all sorts of problems. So he quit at that point, September 2019. Now, this seems like a great failure to accommodate case, but there was a problem in the case from a damage perspective, which is a big part I forgot that I will talk about also at the Huntington Beach program, which was every employment lawyer would look at this case and say, you got no damages. Why? He quit in September 2019. There was a good argument it didn't rise to the level of a constructive discharge for reasons I won't get into now. But then fast forward to March of 2020. Like 6 months later, after he quits, COVID happens. Marriott lays off the entire department of concierge. Marriott does not rehire back any of these concierges. So from the defendant's perspective, okay, no harm, no foul. He quit 6 months earlier. He would have been without a job anyway. Oh, by the way, guess what else? In March 2020 forward, Dan, who had an underlying heart condition, an enlarged heart, his heart condition starts just tanking downward to the point where at the time of trial, he was on the heart transplant list. That heart condition disabled him and prevented him from working most of the time anyway. So, according to the defense, you quit 6 months before you would have lost your job anyway, and your heart condition would have taken your job away anyway. So one of the challenges in that case was damages. And I also came into the case too late to get the experts that I would have had in the first place. So one thing we'll talk about, a big part of the damage discussion in TLU Huntington Beach will be how I made this case a personal injury case, effectively arguing that everything Marriott put him through made his heart conditions decline happen a lot faster. And that case ended up, one of the interesting things, which I don't know if you want to tell me here, that case, when we focus grouped the case, it showed exactly what I worried about the case, that 58% of the jurors were basically split On the question of this 4-year struggle of the accommodations, the jurors were split on liability or not. The focus group jurors felt what I felt when I first saw the case, and what made me say yes to this case was this new renovated workstation was batshit crazy and was not a proper workstation for anybody. But much to my concern and much to what we thought was going to happen, the jury also did not give punitive damages. In the focus groups, less than 45% of the jurors gave punitive damages. So that was the issue in the case. How do we get this case to be a punitive damage case like it should be, and how do we get over the damage issues?
All right. And then you said you got this case, you came in later on this case because you didn't get the experts you wanted. How far before the trial did you come in?
It was a while before the trial, but case was put on hold from COVID issues. So unfortunately, the important point is I came in when experts were basically done in terms of designations. Experts had been selected. I was able to throw one expert into the mix, but the path that co-counsel had chosen was to rely on certain treating doctors, some of whom were not the best and most on-point witnesses, let's just say. So, and discovery was closed other than like a couple of depositions, which each side still had the right to do. So it was, I don't remember timing wise, but that's where we were.
Okay. And now let's talk about the Kaiser trial, because the Kaiser trial, I think Michael Zellman, who was in your class last year, and his partner, who is, what's his partner's name?
Taylor Pranito.
And Taylor, they brought you this case, and you only got this case, what, a week, 2 weeks before trial that they invited you to, they showed you the case and asked for your help?
Yeah, they reached out a few weeks before trial. I had like a nightmare schedule in my end at that point. I formally, I think, came into this case 1 to 2 weeks before trial started. It was supposed to start the Monday after Thanksgiving 2023 last year. The Wednesday before Thanksgiving, both sides mutually went in asking the court to continue for 1 to 2 weeks for lots of reasons, including a key witness unavailability problem. That request was denied, and we started the trial on the Monday after Thanksgiving. And I'll find it's interesting to show you the benefit of TLU for both folks in my shoes, that are speaking, and then for attendees. Michael, who had attended the previous TLU Huntington Beach, where Brennan and I talked about the Edison case, one thing I said in that seminar, which is one of the things I've learned over the years, is when you're trying a retaliation case, what matters to me as much as anything is what's the thing the plaintiff is complaining about? What are they blowing the whistle on? The more serious, the more significant, the more upsetting the thing they're blowing the whistle on, the easier it's going to be to prove they were retaliated for that, especially if instead of handling the plaintiff's complaints the right way, the company covers them up, sweeps them under the rug, and hides them. And I said something like that at the Huntington Beach seminar last year. And I'll never forget the text I got from Michael Zellman, who was in that session, saying, "David, I remember you saying in a retaliation case, one of the things that matters the most to you is how important is the thing that the plaintiff was complaining about. We've got this case going to trial in a couple of weeks where the plaintiff was a nurse reporting patient care issues at Kaiser, and one of the issues led to this traumatic delivery that caused brain injury to a baby. Are you available to try this case?" And I started looking at a few bits and pieces of materials. I wasn't available. The schedule was hell at the time. But I remember when I read a few documents in the case, I remember saying to my wife at the time, "Honey, I know that this schedule doesn't allow it, but I got to try this case."
So how did you decide? You only had a couple of weeks, in your review of the case itself and looking at what key information do you look at before you make the decision, I'm going to be in on this case? I mean, do you read every deposition, or how'd you go about it in this case? Because you had to make some quick decisions here.
So that's a really good question, Dan, and it shows part of the evolution that I've had, that thank goodness I've had, because let me tell you what I used to do, which doesn't work in this situation. Years ago, I would have this fear of not knowing everything about the case and fear that until I know every detail, I can't figure out the story in the case. So years ago, my approach would be to try to read every damn deposition before I start thinking about how to try the case, because I want to get all the data in before I start making decisions. And what that led to was paralysis, because in employment cases, there's lots of depositions. You know, my Edison case from 2022, we had like 65 to 70 depositions. You can't read 65 to 70 depositions, to decide if I'm going to take a case. It just doesn't work. So in this case, what I've now come to be able to do is to hear the bigger picture of the case from the co-counsel, from their mediation brief, from their summary judgment papers, whatever gives you the overview. And then to figure out what are the issues in this case that I think are going to move the jury, and what evidence is black and white, undeniable about those issues. So applying that to the Kaiser case, there was one document that showed a manager had written to our client, quote, "UORs are not always necessary." What's a UOR? A UOR was an unusual occurrence report. An unusual occurrence report was something that was there for care providers like our client, who was the charge nurse in the NICU, to be able to report things that are concerning that happen on any shift, including patient care issues or patient care concerns. So in the Kaiser case, I saw the MSJ papers. I talked to co-counsel about the theory. They gave me this one document that showed management put in writing, UORs are not always necessary. And then they showed me the evidence on why they fired the plaintiff. And then we talked about, okay, what they say the plaintiff did, she did do it. It was a policy violation. Do we have any comparative evidence? Meaning, is there any evidence that shows others, people that did bad stuff that was similar, were not fired, to show the difference in treatment of plaintiff to them? And based on that, literally without reading any depositions, I said yes to the case, because there was a story that was going to be universal that I could see in this case, which is a lot of the client's complaints, they related to understaffing of the unit. They related to Kaiser cutting corners in staffing to save money, and it compromised patient care. Now, as a former med mal lawyer who knows the Kaiser system, I know that that's present in the Kaiser system. The Kaiser nurses a few months before this trial were striking at times because of this issue. So I saw this bigger picture issue that I thought would move a jury, and I saw we had enough proof on that issue. And now that becomes the theory of the case, and now I start digging into the depositions to get the evidence of that. Whereas in the old days, I would do it in reverse. Read everything, can't get through all the data, become paralyzed, freak out, basically.
All right. So, and the issue that they fired the nurse for, what did she do that led to her termination?
So it was a challenging issue, and it was the issue that Kaiser thought there's no way in the world a jury would ever accept, which is our client was a 30-year neonatal intensive care unit NICU charge nurse. The charge nurse is kind of the lead on the shift. The NICU obviously deals with very sick babies, and things like infection control are super important for these very sick babies. The healthy babies don't go to the NICU, only the sick babies do. And our client was there that one day, after the whistleblowing happens, one day an anonymous letter comes in to Kaiser's management, and it has a photo of our client Maria sitting in a recliner. The NICU has these recliner chairs that are there for the parents as they're sitting. The nurses aren't supposed to be sitting in them, really. They're there for the parents. Well, it shows Maria, our client, sitting in the recliner with the recliner in the out position. She's on her cell phone, which you're not supposed to do. And the really bad part, she's got not just her shoes, but her socks Both shoes and socks are off, and her bare feet are resting on the isolette, which is the word nowadays for the incubator that the sick baby is inside. So Kaiser says that is an outrageous, as they said, an egregious violation of, patient safety issues, the thing we're saying she was reporting, because this could be dangerous for the baby. It can be an infection problem. She could have tipped over the isolette crib thing that the baby's in can fall. So they were saying she could have actually tipped it over with her feet and killed the baby or brain damaged the baby. It could have been an infection. And then on top of it, one of these complaints comes in and Kaiser doesn't immediately act to get rid of Maria. So then a week or so later, another one comes in with the same thing. And this one now says, if you guys don't do something, basically, we're going to blast Kaiser on social media about this, that a NICU nurse is doing this. So that evidence was rough, and viewed in isolation, you could say this case is unwinnable. Kaiser felt that way. Kaiser said, no jury's ever going to allow a sick baby, a NICU nurse to put her bare feet on an isolate of a sick baby. We're going to win this case based on that.
Well, that clearly didn't happen. And that's why, because you got these verdicts on both of them, we're able to talk about them. And on June 20th, we're going to do a case analysis on the Marriott case at 10:30 a.m. Pacific time. And on July 19th, we're going to do a case analysis on the Kaiser case. And just so everybody knows what a case analysis is, it's a webinar that we started during the pandemic. And we're going to walk through each trial. It takes about total 2.5 to 3 hours. Everything from, whatever focus groups you did on them ahead of time, to motions in limine, the mini opening, the voir dire, the opening, the order of proof, your witness sequencing and the witnesses you called, who the defense called and how you undermined them, the closing argument, and the rebuttal. And so it's kind of like, but it's obviously unlike this program, it's a multimedia program where we're able to show clips and pieces of trial to really fully help people fully understand how you put these cases together and how you got these results. And those webinars are available live for free, or you can watch them at your leisure if you have TLU on demand. And we also, collect the pleadings, transcripts, and PowerPoints for these cases. So basically, you have a virtual trial library. Because we did a couple other of your trials. I know one of them stands out in your memory, but not for the most positive of reasons. Because before we got, when we were preparing for this, I said, David, what's that one trial, that one verdict, that one case that you have so much regret upon the results of it? Because I think as trial lawyers, we look back on on those cases that we lost or maybe didn't get very good results on, that we could think, God, the lawyer I am today, that shit would have never happened on this case. So, and so which case was that for you?
So it's interesting. The case that fits that was frankly not, I've been lucky, knock on wood. I've only had a couple of straight defense verdicts in first chair employment cases. And it's not those, because the couple times I've lost an employment trial, I actually think the jury made reasonable or potentially even correct results. The case that eats at me still to this day is the one that you and I did all these case analyses on back in the COVID days, in the early days. It's Maria. Interestingly, it's another Maria against Kaiser, but it's Maria Gonzalez, not Maria Gachillian. And it was an associational disability discrimination case I tried back in 2017, I think, in San Diego. And it's, we somehow pulled off victory in the case. The case seemed to be a lot harder in trial than I anticipated it would be. But we got a really bad damage result. We got about $500,000. We did not get punitive damages, and it was a big disappointment in the number. And there's, you'll never know, right? But as I look at what I now know, and I look at how I now structure and frame cases around absolute truth, and I do not bend anything to make the story be what I want it to be, but rather I actually do a much more objective evaluation of the evidence and what I think it will look like, and I accept that. And I don't try to make bullshit arguments that I might have back in the day, almost 10 years, 7, 8 years ago. I really look back on this one and say, could I have framed this case in a better way where there weren't times where I was standing up and selling what might not be reality? And would that have produced a better result in that case had I done it?
All right. Well, let's look at these. I want to talk trial with you now, and specifically, in context of these two cases that you did. And in general, let me just, before we talk about specific trial though, what is your use and view of focus groups to get ready for these? Both, what's your process in getting ready for a trial?
So even though I'm going to, as we start talking, contradict myself right here. Focus groups to me are just the most essential thing of getting ready for trial that there is. I focus group, with one exception we'll get to in a minute. I focus group every case that goes to trial. I focus group plenty of cases that don't go to trial to decide should they go to trial or not. I just believe focus grouping is the most important thing you do in a case. And a focus group done right, and I always do my focus groups with Harry or Claire Plotkin, and we have a very specific method. And nowadays, actually, I've gotten away from, although there are some exceptions, I've gotten away from the focus groups where you argue the case, where lawyers argue the case. I'm doing them all with kind of a written summary online with a series of key exhibits or video testimony there. And what Harry or Claire do is they will do something that makes that is critically important for how we actually try the case and how we do jury selection, which is they'll have a series of potential jury selection questions that each focus group juror fills out first. Then they'll do the presentation, and those will be attitudinal questions, basically. Have you ever seen a coworker, burden other coworkers by a accommodation for a medical condition, for example? Questions like that. They'll get those answers. Then after that, the focus group jurors will read the presentation, review the key documents, and then they'll fill out their verdicts, and then they'll fill out questions and answers about the case. What it does is it generates a report in the long run that basically tells us, and for example, I'm looking at the one that was done on the Marriott case right now. It told us, not only that the data of 58% of the jurors said it was a failure to accommodate only. I'm sorry, 58% failure to engage. 72% felt there was a failure to provide reasonable accommodation, but only 21% of that 72% found it was intentional. In other words, it was a negligent failure to accommodate. So we get very specific data like that, but then we also get a breakdown of what issues were most important. I call it the 80% or more issues. What issues in the case did more than 80% of focus group jurors think we were right about? So in the Marriott case, it was fascinating. The focus group told us that just like I was worried, the 4 years of Mr. Callahan getting a bunch of accommodations and the back and forth, yes, while it wasn't perfect and we had some arguments, jurors were split on that. Jurors were basically 52% our favor, 48% the defense on that 4 years of the case. But guess what? When we got to the new workstation, the renovated workstation in January 2019 that he could not sit down and use without hurting his body, 80% of the jurors, focus group jurors, felt when the Marriott was renovating the workstation, they should have considered Dan's needs. So that told me the path to victory in this case was accurately predicted. It wasn't the 4 years of back and forth. It was what happened when they renovated the workstation and gave him a brand new desk that just didn't work. Now, we also knew that, and the report we always get back also tells us, the critical things for jury selection. And if I can give the most interesting example about that, it's not an employment case, but years ago I was signing on to retry a palimony case. A palimony is Yeah, I saw Dan's look on his face of what? It was the largest at the time palimony verdict in California history. It was a $5.5 million verdict, went up on appeal, got reversed, and got sent back because basically the trial judge thought it was the wrong result. So complicated situation. I got asked to retry the case, and we did with the Plotkins. We did the same kind of focus group there. Guess what we learned? I was representing the woman, suing the man, saying he made a promise of lifetime support. What we learned in that case was 100% of jurors who went on or believed in boys' nights out, just guys going out and hanging out with their friends for the night. 100% of those jurors across multiple focus groups we did defensed the case. So in that case, I knew there was literally one jury selection question because of our focus groups, that if we got an answer to that, we could basically get the people off we needed to get off. So that's the other thing that our focus groups do that I think are so critical. It literally makes it so that when it comes to jury selection, I've got 3, 4, 5 questions that we know from focus group data will determine what this jury is going to be like on this case.
So you said you do this online. So is that, how many jurors do you guys survey online to come to these data points and come to these conclusions?
There's a range depending on the case, and I just did one with Harry that we had 100 jurors online, almost 100. I've had them where we have like 30 to 50. Now, Plotkin has a statistical background, actually, which is one of the things that makes him different than a lot of jury consultants, and he's got a statistical background. So he's all good on what I call the voodoo statistical shit that he does to figure out significance and stuff. But so normally, though, the range has been 30 to 50 is norm. Sometimes now we do them with 100. And I will tell you, I've tried a lot of cases since I hooked up with Harry, probably 13, 14 years ago. And every single case, the focus group has, with one exception, the focus group has been relatively predictive of what that jury would look like based on what we knew they were supposed to be like from the focus group. Now, there was one exception, but that's one where a really bad felony conviction came in the middle of trial that shouldn't have come in, and I think that you have to consider that a one-off. But other than that one case, every time we've tried cases, the focus group has been predictive of, what do we think our jury is like after they're seated, based on the data from the focus group. It's unbelievable.
Wow, because it's like, it sort of seems like the Plotkins are, delving into like mini big data, because, the Campbells who are coming to Huntington Beach and Sean Claggett are releasing a book in Huntington Beach called Jury Ball, and how they use
They're releasing it finally. Yay!
in Huntington Beach. So, it's because they have a lot of studies, and there's actually a lot of people presenting at the conference who got great results and used them and put a lot of emphasis on that information. Like a buddy of mine, Jason Wechter out of Detroit, got like a $28 million motorcycle leg amputation verdict about a month and a half ago. And so he used that. And so obviously, you get that's his first 8-figure verdict. You get your first 8-figure verdict. It's kind of an exciting day. I'm sure for I can't imagine too many trial lawyers that have been doing this 25 years and finally hit 8 figures that aren't like dancing on the ceiling, right? And so
It's a good day.
Yeah, it's a good day. So, but let's talk about the first. Okay, after we get through our focus groups and you got the data you want, now we got to get to the mini opening. In California and a lot of states, they have the mini opening. So give us your philosophy on the mini opening, and then we could talk about the mini openings in these 2 trials.
So my philosophy on mini opening has evolved a little bit in years, but I'm still subscribed to the core belief that a mini opening is not used to persuade or to win. Now, let me also go back for 1 second. I try other kinds of cases. I'm talking today about employment trials. There might be other kinds of cases where I might believe the mini can be effective to advocate a little bit, but generally not. Certainly for employment cases, mini opening has one purpose to me: air out the concerns I have about the case so that we can get an honest and open dialogue about those issues in jury selection. Now, I will say, for years, I might have taken that a little too far, and I think that nowadays that I adjusted a little bit, which is I want to bring out in my mini opening every concern issue, but I also want to tease for the jury, we have a response to this. We're not going to tell it to you now because now's not the time, but I don't want to leave it feeling like the case is complete and utter bullshit and there's no response to what they have to say, if that makes sense. So now, and it's interesting, I've seen this enough where if you do this right, there's an amazing dynamic. Dan, I've told you this story and I'll digress for 2 seconds to tell it. The Edison trial that, that was 464.5 million. It was the largest employment jury verdict of any kind ever in America that we got in 2022. We spent 5 days, because it was a long case, like 8-week case. We spent 5 days picking the jury as there was a COVID surge going on. So it was a very long jury selection process. We had panels of hundreds, brought in and out. We had the big courtroom in Mosque to do it. So I had to give this mini opening a lot of times. The defense lawyer in that case gave a mini opening that advocated her case as hard as imaginable. I got up and gave a mini opening that brought out all the bad facts of our case and suggested to the jury there is another side of the story. We went on for some of these jurors that made it on our panel of 12, they started off on day 1 and they sat through this for 5 days. And they heard the defense lawyer advocating what a bullshit case we had. And they heard me not advocating. When I got up for opening statement in that case, I will never forget. We had good evidence in that case. I came on really strong in opening, which I don't normally do. And I came on strong just because the case involved a filthy, disgusting, toxic, hostile workplace. So I'll never forget in the first 10 minutes of opening, when I started telling the jury what the evidence would show, the filth that came out of these mouths of these supervisors, the entire panel, it looked like their eyes were popping out of their head because we had so undersold the case in our mini. And the defense lawyer had so oversold. I'll never forget this feeling of eyes popping out. They couldn't believe what was coming out of my mouth. And after their eyes popped out at me, they shot looks to the defense lawyer like, are you kidding me? And I don't think she ever recovered. I don't think her credibility ever recovered from that. Now, she did a lot of things that made her credibility go worse down the road. But that changed, and it reminded me of, Dan, I'm a huge consumer of Dan's platform. I still go on the on-demand and listen myself, and I recommend everybody do because there's no greater collection of stuff to learn how to try lawsuits than what Dan has put together. And I still consume these panels all the time. And I remember one that Rex Paris, who's to me the lawyer master of cognitive science in the country. Rex had given a speech in one of Dan's presentations that talked about that if you can actually get people to, it's rare to get people to change their mind, but if you actually get them to change their mind and flip, they will hold the new opinion and fight for the new opinion and new perspective harder than otherwise. So in other words, if you get them to flip their perspective, they're going to go in and fight for that new perspective and they're going to hold on to it. I saw that in this Edison case. They thought my case was bullshit through 5 days of jury selections and 5 days of mini opening. And within 10 to 15 minutes of what became a 2+ hour opening, they changed their minds. And those jurors were with us at that point and never left us. And they were never going to leave us, I feel, because of that change. So to me, that's the perfect example of how a mini opening process should be done. And the fortunate thing is most of the defense folks, at least in the employment space, they advocate in their mini openings. They go too far. They don't try a lot of cases. They got no idea what the stuff we're talking about here. They're big firm lawyers, and they're not usually trial lawyers.
So now that we have your philosophy on the meeting and how you did it here, kind of, I know it's been a while, but just to the best of your ability, tell us what you said to the jury in that mini opening on, well, not on the
The
case,
Marriott
but on
one.
the Marriott case.
So, there's always the minis, and I will tell you also, Plotkin writes my minis. I might tweak them, but minis and jury selection in my world, Plotkin does. I make sure I'm okay with it, and then I just do what he says. So the mini in the Callahan case, we always start off with, this is an important, the good morning, and this is an important case, and we know you may not be thrilled to be here, but we're so thankful that you're here because those of you who are on this, who are willing and chosen to serve as jurors, will get to make important decisions about how companies treat employees with physical disabilities. So the first paragraph always is about, you're going to make important decisions about whatever the issue is. In Marriott, it was, how employees treat workers with physical disabilities. In Kaiser, the case, it was important decisions about how seriously hospitals should treat reports of patient safety violations and how fairly they should have to treat employees who stand up for patient safety. So that first paragraph gets a little bit of our theme out. After that first paragraph, it's bring out the bad. So, in the Marriott case, it was after my introduction. In 2014, Dan Callahan suffered a permanent spinal cord injury called incomplete paraplegia from an epidural gone wrong. When he returned to work in 2015, he and his doctor gave Marriott some workplace restrictions and requests for accommodations to allow him to keep doing the job. This lawsuit is about how Marriott handled those requests over the next 4 years. And you'll hear the facts about what Marriott did and didn't do. And Marriott didn't do nothing. There were many meetings and attempts were made. So there I'm introducing the first bad thing. Marriott did a lot. But we then say, but you'll get to judge whether the real decision makers at Marriott were really trying to do their best for Dan or not. That was introducing the theme that the real decision makers were not the people that they were going to hear from in the trial. The people they were going to hear from in the trial might have tried their best, but somebody up above in management blocked the real accommodation. So then we went to, you'll hear the impact Marriott's treatment had on Dan, on his health and quality of life. And that's what we're suing over, his health and quality of life. We're not suing over lost income because Mr. Callahan quit the job. So that was getting out. We're not here for lost income. We're only here for quality of life damages, pain and suffering. Then it went to, you'll get to decide if Marriott's treatment of Dan Callahan damaged him physically and mentally, whether they caused him such severe stress that it badly triggered severe heart problems he now has, making his heart condition that he already had much worse. We're getting out the heart issue. Then we're getting into the real bad facts on the heart condition. You'll hear Mr. Callahan's health wasn't perfect before Marriott. Many decades ago, he abused drugs and alcohol. He took prescribed opioids for years to deal with his pain. He had these pre-existing heart problems, but you'll hear he didn't have very bad symptoms. So that's how I treat mini opening. It's, we bring out the bad, but then we do a little bit of the counter response. And then it just went, and you'll get to decide if the extreme stress and suffering that Marriott put him through made that heart condition worse to the point that it became something very severe. Then we have a standard paragraph about holding them fully accountable. And then I always end the mini opening with, and I want to be upfront with you now that we'll be asking the jury to agree that it will take many, many millions of dollars to hold the company with the resources the size of Marriott fully accountable for how they treated Dan Callahan and to punish them to send a message. So that's something like what the Callahan mini opening was.
Okay. And now how about the Kaiser mini opening?
The Kaiser mini opening, I think we were only given 3 minutes. The Kaiser case, we had 16 hours per side to try the case. It went a lot faster. So that case was and I could just try to give it right now. Something like, "Good morning, everyone. This is an important case, and even though I know you're not thrilled to be here on jury duty, we're so thankful that you are, because those who are willing and chosen to serve on our jury will get to make important decisions about how seriously hospitals should have to treat reports of patient safety violations and how fairly they should have to treat employees who stand up for patient safety." My name's David deRubertis. I'm honored to represent Maria Gachillian, who worked for Kaiser as a charge nurse in the Woodland Hills Hospital for 30 years. Now is not the time to tell you all the facts of this case. That's what the trial is for. But in June of 2019, Kaiser fired Maria. And if you're chosen to serve on this jury, you'll get to decide for yourselves why Kaiser really fired her. And if the reason they say is the truth, or a false reason to cover up an illegal reason. Kaiser will tell you they fired Maria for violating company policy. We'll show you evidence that Ms. Gachillian had been making reports about things that she believed were potential patient safety violations. And you'll get to see how Kaiser handled those reports and decide for yourself if the real reason they fired her was to silence her from continuing to make and document those complaints. You'll hear it's true that Ms. Gachillian admitted to Kaiser that she violated policy. Someone sent a photo of a nurse putting her bare feet up on a crib that was holding the baby in the NICU. And Ms. Gachillian admitted to Kaiser that it was her and she did this. You'll also see how Kaiser handled other policy violations by healthcare providers. And you'll get to decide for yourself if the reason they say they fired her doing this thing this one time, if that makes sense. And if the facts can, so that was the big part. Then we went into the typical ending where we say, if the facts show you this was the case, you'll get to decide, the damage stuff. But there, what was important, this one was interesting because it was a little bit more pushing our themes out. We felt in this one, the photo of what Maria did was really bad, and you could just have a visceral reaction to it. So this, I think, one argued a little bit more. It got it out. It admitted she did it, admitted she did bad, but it kept throwing out the idea that it may not be the real reason, and you've got to contrast what they did to Maria with what they did in other situations, which was a really big theme of our case.
So moving on, after we set up the voir dire with the mini opening, let's talk about your approach to the voir dire and these two Pacific trials. Especially when you first stand up there, do you have I don't know if I call it like a routine, a shtick, whatever you do before you get into the substance, where you just kind of warm up the jury a little bit, or they warm up to you a little bit before we start digging into potential biases and challenges for cause or preemptory information stuff, digging into information?
I don't have a long setup myself. I generally start with a very short kind of, good morning, thank you all for being here again. And I just start off saying, look, and let me also say, what I do nowadays is affected by the time limits. In most California courts, you don't get a lot of time to pick juries. So 5 minutes of fluff warm up means, a lot of time when you're getting 30 minutes or 60 minutes for 60 people. So I get right to the point. And I basically say something about, this case is after the thank you, and I don't rush the thank you, but I say something about this case is extremely, extremely important. It's important to my client, Mr. Callahan, and it's important because of the things we're here to talk about and the laws we're here to enforce. I always want the importance of our civil rights laws basically out there. And then I say, and because it's such an important case, I don't want to mess up and destroy Mr. Callahan's only chances of getting a jury that is right and fair for this case by not asking the right questions. So I'm going to spend my time talking to you about questions about things I worry about in this case and things I fear may rub you the wrong way about this case. And I used to tell jurors there's no such thing as a wrong answer in jury selection, and I don't say that anymore because The more I thought about it, the more I realized there are wrong answers. The wrong answers are the answers that aren't the truth and the whole truth and nothing but the truth. So the only thing I'm going to ask of you is, can you just, for this part of the trial, the only time where we get to talk to each other, can you just tell me the truth, the whole truth, and nothing but the truth, even if you think I don't want to hear it? Because I really do. So something like that.
That's a great setup. All right. So after we do the setup, what are the specific issues? Let's talk about the Marriott first, that you thought, that worried you, that you had to talk about in voir dire.
So in the Marriott case, if I can find it, the beauty is we had our little jury selection, analysis from the focus group, and it told us, and this is, a 2-page summary of 6 issues that were the worst issues for jurors in our case. Item 1, the worst jurors who have seen workplace fakers and liars. 80% of people who, quote, have seen someone make a false accusation of discrimination, racism, or sexism in the workplace defensed us. 75% who have, quote, seen someone or known someone falsely accused of harassment defensed us. So literally, that's my jury selection process. We've got 5 or 6 issues that these are the people we want off, and then we have the corresponding, these are the people we want on. So in the Marriott case, I'm just looking that, and again, Harry does all my questions and then we work through them, but the first series of questions for strikes went to people who disagree with employment lawsuits generally. So this became, generally, there were 2 categories the focus group showed. Those who believe when something goes wrong at work, you should quit and move on. The quit and move on jurors, often bad for plaintiffs in employment cases because they don't value the job enough. That, some good jurors tend to say, I shouldn't have to quit. I love this job. I've worked for it. I should get fairness. Bad jurors will say, what's the big deal? Quit, move on. So one question in that category was the quit and move on jurors, and it correlated with the focus group finding. The other question was,
just to be clear, what is that question? What is the quit and move on question?
It's exactly that. Is there anyone here who thinks that if you get mistreated at work, is there anyone here that feels that you should just quit and move on? That's literally the question. So anyone here feels that way, that you're mistreated at work, you shouldn't file a lawsuit, you shouldn't do anything, you should just quit and move on.
And you have,
so that's the question.
Okay, and people raised their hand that said they should just do that?
Yeah. And those, the quit and move on jurors were, in the focus groups, were like 70+% defense jurors.
Got it. All right. And so what other topics as far as?
So the next topic is jurors who were not outraged by delays in accommodations. Jurors who thought you should provide an accommodation quickly and immediately were great for us. Those who thought delays at big corporations are just a function of shit takes a long time at a big corporation. So there it was. Show of hands, how many of you have dealt with a company's process of approving anything? Whether it's approving a request for vacation time, a hiring approval, a promotion or termination request, or even a business expense. People showed hands. Then the question became, what did your experience or observations tell you about whether big companies have the ability to quickly approve something that matters, or whether the approval process just takes a long time and it has delays even for something that matters to upper management. So it's basically that. Who thinks that a big company is able to approve things quickly? Who thinks that there's just bureaucracy? That's what we were trying to figure out, basically. And there's more sub-questions within it, but that was the big topic.
Got it. Any more big topics as far as the Marriott goes?
We also had to, and this came back to, the next big topic was jurors who think injured employees should not be working, basically. So that was, has anyone here ever worked for a company that employed someone with a physical handicap or limitation, by giving them accommodation? Yes. All right. So we get show of hands. And there are a couple of setup questions, but it led to
the following, which was the payoff question. Now, I think we could all agree that some people with certain physical disabilities simply can't do the job. For example, someone paralyzed in a wheelchair can't be a firefighter. It just won't work. Being brutally honest, though, what are your feelings about whether employees with physical handicaps and limitations should just find a job they can easily do instead of demanding that their employer bend over backwards, accommodating their restrictions? So that was, the ultimate payoff there.
All right.
And again, the same deal. The jurors that thought that if you're injured, you should just go find a different job. Those were the big ones. Now, we also had, I won't go through them because I think but we also had a question about, not an informational question. Most of my view is jury selection questions are informational, but there are some times where you need to get a concept out. And we had a question in here that was getting the concept of concurrent causation on the heart, because the jury was going to hear the client had a cocaine problem for years. The client was a very severe alcoholic for years. The client took opioids for many, many years, and the client took an extra form of testosterone injection, often used by bodybuilders. So they were going to hear all of that. And we had to get the theme out that more things can contribute to a physical problem than one. We're not disagreeing those things caused some of the problem, but the question under the law is, did what Marriott do make it worse? So we had one question out there that I just, unlike normally I don't do these kind of theme advancing questions in jury selection. Here I felt it was important. And then we have the typical jurors who minimize damage questions that we asked as well in punitive damages.
And how did you talk about money? Because employment cases are different because most of the damages are non-economic, somewhat, anxiety, depression, whatever the heck the mistreatment caused them. And they're not like the, paraplegia, the missing limbs, the broken back that you have in a PI case. So how do you talk about damages in these employment cases?
Let me illustrate with the Marriott one again, just because it's what's in front of me. And it was a buildup. So we started off with basically saying, hey, so in a civil lawsuit like this, money compensation is the only thing a person that's been harmed and mistreated by the employer can ask for. Mr. Callahan isn't allowed to sue to get Marriott to change its workplace, to fix the workstation. He's not allowed to sue to get them to bring him back to work. Money is the only power a jury has over a company that breaks the rights of the employees. And right there, I think that's important because it's talking, now it flipped it. It flipped it from Mr. Callahan cannot do this to the jury. And how? It says money is the only power a jury has over a company that breaks employees' rights. So now they're getting, we're getting out there, money is your power effectively. And if you find that happened here, that they broke his rights, you can't force this company to fix its business practices or take employee rights more seriously. Money is the only way to hold them fully accountable. So before you volunteer for a job that may involve calculating compensation for suffering, money for suffering, here's your only chance to tell me. Do any of you feel uncomfortable doing that? Or do you feel that because you feel that these kinds of you don't agree with these kinds of lawsuits asking for money for losing a job? So we started off that way. And then we transition after we get some dialogue going to, now in this lawsuit, we are not asking for a single dollar for lost income because we say the harm that Marriott caused Mr. Callahan was much, much more severe than the loss of his paycheck. The main thing we're asking for compensation, the jury to compensate him for, is harm to his health and quality of life, the stress, the suffering, the trauma they caused him. So I have to ask you, what are your feelings about whether our system of using money to put a value on health or quality of life? The only ways that we can hold a corporation fully accountable, does that seem fair to you or not fair? Tell me about that. So we do that. And then we transitioned to, at the end of this trial, if you're not convinced that Mr. Callahan's rights were broken, if we don't prove our case, can you all promise to award him zero? We should get nothing if we don't prove our case. Everyone fine with that? Of course. All right, but if you're convinced Marriott did mistreat him, they did violate his rights and they damaged his body and his quality of life, are you open, just open to the possibility that it could take tens of millions of dollars to hold Marriott fully accountable? So that was pretty much how we ended it. And in this case, we moved a little bit further. This case, we actually did go a little bit further. We talked about punitive damages. So the tens of millions was for his health. And then we said, the other thing I want to talk about is, if you think Marriott deserves to be punished, you'll have the power to decide punitive damages. And the purpose of punitive damages is to punish wrongdoing, to make it too expensive, to teach them a lesson so they'll never do this again. Now, if you think about it, think about a fine for a speeding ticket. If a fine for a speeding ticket was $10,000, how many of us here would drive slower? And we all put our hands up, right? But what if it's Jeff Bezos or Elon Musk? Do you really think that Jeff Bezos or Elon Musk would drive slower in the same way we would if the fine was $10,000? So I have to ask you, are you open to the possibility that the larger and wealthier the company, the larger the punitive damage verdict has to be to change their behavior? So that was sort of our last question.
And what was the result? What was the final verdict? I never asked you. What was the final verdict on the Marriott case?
The final verdict on the Marriott case was $5 million non-economics and $15 million punitives for a total of 20. Now, this case was tried in San Francisco, and believe it or not, while San Francisco jurors are tremendously progressive and they were great on disability rights, they're not as good on money damages as you would believe. I think this case tried in LA would have been 50 million or more easily. The 20 million total verdict was the largest employment single plaintiff verdict ever in San Francisco Superior, and the 5 million non-economic was the largest non-economic verdict in San Francisco Superior ever.
Those are pretty good results. And now let's talk about the Kaiser. I never asked you what was the result in the Kaiser case before we talk about the voir dire, because these plaintiffs lawyers, deRubertis, they're all results oriented. Everybody wants to know what the number is.
So the Kaiser case was a total of 41,490,000. It was we had about 2.5 million or 2.49 million in non-economic damages. I'm sorry, in economic damages. They gave us that request to the T. The non-economics, the emotional distress, was 9 million for 11.5 compensatories. We had 2 Kaiser entities in the case. They each got found liable for punitives, 15 million each, for a total punitive damage verdict of 30 million. So 41.49.
All right. And the voir dire in the Kaiser case, I assume the parts of it mirror the Marriott case as far as the intro, as far as the money, as far as the punitive damages discussion. But what specific topic discussions did you have in the Kaiser case? Because you had different issues.
Kaiser was tough because if memory serves me right, we had 60 minutes for 60 jurors.
That's seems almost impossible, especially it seems like in violation of California law, where they're not supposed to have these preset arbitrary limits. But that's just the law. That's not what the judges actually do in the courtroom. I actually stopped by that. Remember, I stopped by that trial and said hi to you there. I saw you. I saw the plaintiff was testifying when I came by, and they talked about the feet up on the bed or up on the crib thing. So it was interesting times there.
So Kaiser had now I will tell you, even though I've already told you focus groups are the essential thing for me, the Kaiser case is the first case I've tried in probably 15 years that we didn't focus group. And it was just a function of impossibility given when I came into the case. I couldn't get up to the speed, figure out how to try it, and run the focus group in time. So it was the first time I've tried a case in, like I said, about 15 years without the focus group data. I'm not going to, just because the result was good, I'm not going to keep doing that. But so this we, Harry again, Plotkin worked through this, and we had only 3 topics that we covered in jury selection because we had so little time. One of the topics was the same type of damage and punitive damage review that I just did with the Marriott case. The 2 independent topics were: 1, strike jurors who don't get outraged by covering up patient safety issues. This case was about they covered up patient safety issues because the truth of what was going on at Kaiser was they were cutting corners with staffing to save money, putting profits over patient safety. And this is the dirty side of what business of medicine has become at Kaiser. That was the case to me. So there were 2 topics only in jury selection other than damages. The striking jurors who covered up patient safety was covered by the following: what are your feelings about whether it's, and this was just an open up question, what are your feelings about whether it's worth the time, effort, and expense for hospitals to document and investigate every single alleged patient safety violation made by doctors or nurses so we can prevent future mistakes? Or does documenting every single allegation like that seem unreasonable and excessive to you? Then the next question was sort of, let's talk about the difference on this between doctors, nurses, and other kinds of professions. So when a librarian puts a book back on the wrong spot, there's no need to investigate that mistake. It's just a mistake, right? But being brutally honest, do any of you feel like it's unfair or overkill to expect a hospital to do something every time a doctor or nurse makes a mistake that potentially puts a patient in danger? How many of you have? So that was basically it. It was, do you think every allegation should be documented and investigated, or do you think that's too much? That was number 1 issue. Number 2 issue was, in this case, Taylor and Mike, Taylor worked up the case primarily, and she had done an amazing job of developing what's called comparative evidence, meaning other instances of similar policy violations that did not lead to termination. So selective enforcement was a very big theme in the case. Yes, Maria violated a policy. She shouldn't have done this, but a 30-year exceptional charge nurse with an unblemished record doesn't get fired at Kaiser over this one stupid thing to do. You require a lot more bad in order to fire at Kaiser. So that second topic became, strike jurors who don't think consistent enforcement of policies should be required. It was, when it comes to enforcing their own rules, what are your feelings about whether employers should have the right to use their own discretion? Meaning it's okay for an employer to fire an employee for violating the same policies that others violated and weren't fired or punished for. And then during this trial, you'll get to hear about how Kaiser responded to different kinds of complaints about employee violations. Do you think you can figure out what a company's motives and priorities are from how seriously they take one kind of complaint or another? Tell me about that. Then that led into, the reason I ask is that the jury's job in this trial will be to decide for yourself what Kaiser's real motives were for firing Maria, based on your common sense. You're not going to hear a confession. They're not going to admit it. There's not going to be an email that says, let's fire Maria to get her to stop complaining. So my question is, can you be a detective in this case? Was it because she put her feet up on that crib? Or did they fire her to silence her and cover up her continued patient safety complaints? Do any of you feel that you don't trust your own common sense or judgment enough to make that call without being able to read their minds and without there being a confession? So that's a little bit beyond the topic of it, but it gets in the concept, which I'd like to do in employment cases, a termination case, about, are you okay? Like, we've got to get jurors to think, you don't just accept what the employer says. Are you willing to use your common sense and think it through and look at all the evidence and figure out, is it the truth or is it bullshit? And I think that helps framing kind of the juror's job for them. So we mixed that in there. But those two issues and damages were all we got to do in the Kaiser case.
All right, let's talk about opening statement and your philosophy on it and how you prepare for it. So let's talk Marriott.
Sure. So, it's interesting. I believe in most employment cases, and look, I try injury cases too, and there are some injury cases where the event is so simple that happened that you can win liability in your opening statement. I don't believe employment cases are like that. I think employment cases have too many complexities, too many nuances, and too much credibility at stake for an credibility of witnesses, because often they're saying two totally different things, that I don't believe you can usually win the case in opening. My goal in opening goals are twofold. Number one, to be in the game, to sit down from opening and sit down from the defense opening, and to at least be in the ballpark where the jury is sufficiently with us that they're not yet against us. If we're a little bit ahead, great, but I at least want to be even and not losing, number one. Number two, I want to give the conceptual framework of our case, like that advances our themes. And by that I mean, and if it's okay, so what I do a lot now, and I've started to really do this, and in the last 2 years, every employment trial I've done this. I will break the entire case down to a four. Marriott, I broke down to 4 points. The Edison case, it was a complicated case. I think it was about 8 to 9 points. The Kaiser case was 6 points. And I will get the jury to see those 4 points. In Marriott, it was, and so right after I do my intro and my thank yous, I go right into, we're going to walk through the evidence, and I'm going to walk you through the story of this case. But I think you can understand the story of this case from understanding 4 points. And these 4 points sum up the entire case. Number one, Dan Callahan had a serious disability that required accommodations. If he didn't get those accommodations, that could aggravate and make his disabilities and other conditions he had much worse. Number two, in the 5 years he worked at Marriott after his injury, Marriott never at any point in time fully accommodated him. You'll see they did some things at some times, but never in those 5 years did they provide every accommodation he needed. Number three, in the last year, 2019, Marriott committed the worst of 5 years of failing to accommodate, by far. They gave him a new workstation that was a kill shot on his body's ability to survive. They gave him a new workstation that would never work for his body. And number four, this 5-year struggle, especially the last 4 months in 2019, pushed Mr. Callahan's mind and his body, both his chronic pain condition and his heart condition, over the edge so he could never work again. They triggered a downward spiral, and he'll never be the same. So those 4 points now, I'm structuring the rest of the opening around. And it makes it, and those were a lot more wordy than I think they should have been. I will tell you, I struggled like crazy on this opening because I wanted to start the opening off going right to 2019 to the workstation that was all batshit crazy. And I had it structured that way until the day before and the morning of the opening because it just didn't work that way. So I retweaked it and told it more chronological. But, so my point in opening, don't lose, stay in the game, be able to summarize this case into 4 or 5 or 3 chunks of information that then is the structure for the opening, and get the themes out. And then walk through the kind of key documents, That's how, that was what the Marriott one was.
Do you mention the money in the opening?
Good question. I have a difference depending on an employment case or a PI case. An injury or death case, I usually will. In an employment case, I will rarely use actual numbers. I will instead do things like And I'm just looking right now at what I did. I will usually do for damages at the end of the opening, I will usually talk about our human losses, the loss of the quality of life, the suffering, the physical pain, etc., are way, way greater than the money losses in the case. So I'll get that concept out. Then I will get out the concept it will take many, many millions of dollars. I think in Marriott I said tens of millions of dollars to compensate the physical harm or for the non-economic harm. And then I always get to punitive damages. And then the most important part of this case, to finish your job of jurors, make the finding that allows you to use the most awesome power you have as jurors, punishment damages. And that's usually how we end.
And let's talk about Kaiser, those key points in Kaiser.
The key points in Kaiser were: one, Maria repeatedly made formal documented complaints. Complaints are disclosures of information that Kaiser management of things she believed were compromising patient care and quality of care. Number two, Kaiser management repeatedly discouraged her and told her to stop making formal documented complaints. Three, Maria kept making formal documented complaints. Four, upset or continued making of formal documented complaints after they told her to stop making them. Kaiser management found the convenient excuse they wanted to fire her, and they ran with it. Five, human resources, whose job is supposed to be to protect workers from management got wrong, had concerns about Maria's termination, but they let management terminate her anyway. And six, firing Maria after 30 years caused the destruction of her quality of life and her mental health. Those were the 6 points that case was ultimately framed around. And then, with Kaiser, it was important to start off. Then the opening transition to something that wasn't in those points, which normally they're fully encompassed, but it was important that the jury understand the business of medicine at Kaiser. So after those points, I went to, let's talk about Kaiser. They're both an insurance company and a delivery, a hospital, basically. And they're unique in medicine because they're also an insurance company. And what that means is they charge every member a fixed flat amount every month. And in exchange for that premium, that fixed flat amount every month, Kaiser's required to deliver all medically necessary care. And that's different than a fee for service, which some people are used to, where you go to the doctor and you pay for it. Why is this all important? It's all important because at Kaiser, you can only get so much money from the members. If you're worried about the money you're making as a corporation, the place to fix that and to increase the profits is to cut expenses. And the big expense they cut, you'll see in this case, is staffing. They're constantly cutting corners with staffing to make more money, compromising patient care.
These opening statements, do you practice or rehearse them at all prior to giving them live to that jury?
So I had that horrible suffering of watching myself in that damn Gonzalez versus Kaiser case that I was struggling to get ready for in 2017. And it wasn't mesh. The way to try the case just wasn't meshing. And I was struggling with it. And I was completely not comfortable with how things were going. And I'll never forget watching, and I didn't know CVN was coming to that trial, and they showed up for opening statement. I'm like, are you kidding me? Of all cases for them to show up to, it's this one. And you may remember, Dan, in the case analysis we did on this, I had this damn clipboard in my hand, and I had these notes, and it was painful to watch. So I'm not a amazing memorizer of things. I don't memorize speeches. I can't do it. Memorizing the 3-minute mini opening takes me hours. It's my least favorite part of the case because I'm just a slow memorizer. So what I do is I create kind of written bullet points for me, and my process of creating this outline, like my Kaiser outline for opening was 19 pages of notes. And then I will just in my head, like, what am I going to say? What am I going to say? What am I going to say? The words always come out differently, but I'm constantly rehearsing in my own mind every moment the chunks of, opening or closing, whichever it is. And I do my damnedest now after suffering through my clipboard in my hand, looking at my notes in that Gonzalez versus Kaiser case. I do my damnedest to put it down and just to talk. And if I'm forgetting something, it's in front of me, and I'll look at the paper and pause, and then I'll come back to deliver.
Do you use many visuals in your opening, or video clips of depositions of the defendants and stuff like that?
Sometimes, but I will say the past 2 years, all three of these trials, I have done, the only thing I've had as a visual in opening was any actual case documents, exhibits that were pre-admitted basically. And I actually did all three of these trials without demonstrative, without video clips in opening. And just, thank goodness, I think from those Trojan horse days and from like just the work you've done, I think I've gotten a lot better at the parts I used to struggle in a trial, which was the presentation. I think I've my roots of getting to where I am as a trial lawyer were from strategies and substance of how you try a case, and from, I think I'm good at 776 exams of adverse witnesses, and your work has made me focus a lot more on the presentation, and I thank you for that. And I feel super comfortable now getting up, and Edison, I think I gave a two hour, 15-minute opening without a demonstrative, and the jury was riveted. I ran all around the courtroom. I used myself as a demonstrative. I used the courtroom space, but I've gotten, interestingly, beginning of my career, I was all about the visuals. I wasn't ready to try a case until I created the visuals. I've been trying cases with less and less visuals nowadays, and I've been spending more time making visuals on butcher block during the trial if the judge will allow it.
Butcher paper. Just
Yes.
what butcher block means. And I find that to be interesting because more and more of these interviews that I do with the case analysis is more and more people are using less and less visuals. And I can see the effectiveness because every time you get that visual up there, it distracts the jury from their connection with you. And I know Mark Lanier is the guy with the visual strategy and everything, but I just, there's so many lawyers that everything they do has a visual. They get up and it has the case caption as a visual. Everything to draw the attention away from the trial lawyer and towards something that's not going to connect with them. So I just,
Yeah, it's fascinating because literally you can go on the internet and find all these articles I've written about the importance of visuals in trials. And, three of my greatest trial results had no visuals.
No, it's just,
So,
and that's the important thing too, as to continue to rethink and evolve everything we do in the courtroom to constantly strive to get better, to get more effective, to be more persuasive. Let's move on to the your order of proof in these two cases and how you approached that in the Marriott case. Who'd you call first, the sequencing of witnesses, and putting your case together.
so I think your order of proof, your sequencing of your witnesses in employment cases is it's one of the areas you win or lose. It just really is. Employment cases are beautiful to be the plaintiff side trial lawyer on because you have so many choices of witnesses. These cases have a lot of witnesses usually. And even these two cases, which had a small amount of witnesses comparatively, they still had a lot of choices. And I think going first and structuring and sequencing witnesses is in the top three things to achieve success as an employment trial lawyer. In the Marriott case, it was interesting. My view of the case, the focus group data showed us the workplace, the new workstation, the renovated workstation, which in opening I said was the kill shot to Dan's ability to keep working. That was our turf. The 4 years of back and forth before that was the defense's turf. So I wanted to start this case off witness-wise going to our turf. So the first witness I put on the stand was the Marriott's occupational health nurse. They had an occupational health nurse who was on premises, who Marriott's lawyers got up in opening and said, look at what a good company we are and how much we care about workers. We have an occupational health nurse on premises. We care about workers' health. So I called her first. Now, the theory I had of the case was not the theory she was deposed on. She was deposed largely on the 4 years of back and forth and a little bit on the year that I thought mattered, 2019, after the new workstation. But, you know, I also know if you know how to do 776 exams and you understand the psychology of witnesses, you can get them to tell the truth. And I'll never forget, there was debate on our side about, do you start with her? She's super nice. She was not a bad actor. She was not a villain. And starting with her might be bad unless I could completely get her to agree with everything our case was about. And I was 100% confident, even though I was asking all these questions that were not covered in depo, she'll admit the case. She has to, because she's an expert in this subject matter. And I know this subject matter of ergonomic workplaces or workstations. And so the bottom line is we put her on the stand first. I put her on under 776, which is California's version of calling an adverse witness. And I went right to, I covered with her at first the disability policies, the workplace safety policy, and how having a properly designed workstation is actually part of Marriott's workplace safety policies. It's not just some special accommodation. It's part of their basic duty in their own handbook to provide you with a safe workplace and a healthy workplace. She agrees with all this. And then I put up the photo of this workstation and ultimately started going through her knowledge as an occupational health nurse of body ergonomics of a workstation. That there's literally measurements on how far you're supposed to reach, how far you're supposed to, bend. And she gave it all to me. And the long story short is it got to the point where I asked her, so you're the expert. You're the person that's here to help these workers. When Marriott was doing this renovation, this $150 million renovation, did any of the high up managers in charge of that, did they come to you and ask you what you thought of this workstation? She's like, no. I'm like, if they had done that, you would have told them this workstation is not right for Mr. Callahan's body, wouldn't you have? And I'll never forget, she's like, I would have told them it would be ideal for there to be leg space. And I said, you would have gone further, wouldn't you? You would have actually told them this workstation is not right for Dan Callahan's body. Answer, yes. The occupational health nurse, they just told the jury in opening, is such a great thing because they're such a great company for having her. They didn't even ask her opinion about the desk. And within 2 hours of the trial, the evidence starting, she agreed he shouldn't have been given this. So that's how we started to just go right to the issue. Now, after her, we had an ergonomist expert, but frankly, I didn't need him anymore almost because she gave it all to me. So I put the ergonomist expert on next, though, really quickly just to confirm what she had just said. And then we moved on to the HR people. First, the HR person who was trying to get our guy to help basically. And then after that, the kind of higher up HR person. And then after the two HR people, we went to a video depo that wasn't that big of a deal. And then our final witness before transitioning to damages was another video depo. And by now there had been this kind of momentum in the case. It started off with this immediate concession of liability almost about the workstation. And then we built more through these other two HR people. And fortunately, the second HR person went too far with her on their direct. So I was able to hit her really hard on cross. But then we ended the liability phase with one nasty video clip. One of the issues was that Dan needed a break room where he could actually sit down and have a table to eat at. And whenever he would go to the break room, someone else would be using the table. So the management intervened and said, look, this is Dan's table. It needs to stay here. Well, guess what? One day the table was gone. And Dan reported that to the kind of director of the concierge. And she made this nasty comment in her video depo of, that wasn't even his table. And anyway, it was just around the corner. Well, to an incomplete paraplegic, it didn't matter that it was only 4 feet away. He couldn't move the damn table himself. So we strategically saved that to be the very last testimony on liability before we transitioned to damages. And I think it was perfect because at that point, jury was pissed now. When they heard that in the context of everything they had already heard, already with us, you could just feel them turn to an anger moment at that point.
And as far as damages witnesses, tell us about the ones that you put up there to get this result.
Then we went to Dan's internist, who was a challenging witness. He was a good guy and a good doctor, but all over the place and just kind of scattered. And I realized it would be really hard to do his exam in trial. So the defense took his depo, and we, thank goodness, got them to save like an hour and a half of time in his depo on like the third day of it. And I actually did his trial exam in a video depo where the defense didn't realize that's what was happening. So it was my time to ask questions in the video depo, and I started, doctor, introduce yourself to the jury. And the defense lawyer goes, objection, I'm confused. There's no jury here. I don't understand what you're doing. And this defense lawyer was an asshole. He refused to produce a witness for deposition other than on a day that he knew my wife was having surgery, and I was pissed because I couldn't take her to her surgery. So I was, I'm normally very civil. To him, I lost civility after that because he knew what he was doing. He was trying to get it so I couldn't take the depo. So I'll never forget when he's like, objection, I don't know what you're doing. My answer was, you don't have to know what I'm doing. Doctor, would you please introduce yourself to the jury? And I did about an 1.5 minute direct exam. And the defense lawyer afterwards floundered for 10 minutes with totally useless cross-examination. So we played that video to begin our damage claim, basically. I just played the video of the doc, and there was, no cross-examination. Now the judge, I think this was a wrong call, but the judge let them bring the doctor back in their case. So after we did that doctor, the internist, and he's the only person, an internist, he's the only one I had to try to advance the cardiac aspect of the case. Never mind that in my client's medical malpractice case a few years back, the doctor testified he would defer to cardiologists about the heart. So we'll put that aside. But in any event, so we did that doctor, then we put the client on a little bit, and then we put the UCSF treating neurologist who talked about the pain condition and the accommodations. And then we went back to client's wife, and therapist ended the case.
All right. Now let's talk about Kaiser, the order of proof on Kaisers.
Sure, and Kaiser, I'll be a bit quicker. Basically, the Kaiser trial, we started it off with the main HR person. And the reason, the overall sequencing, I won't go through each witness individually just because I see the time, but the sequencing of these witnesses was, we wanted to sequence it so that the beginning of the case was focusing on complaints about patient safety and the lack of investigation, the cover-up. So I wanted to punt the question of termination. I didn't want to go, in the old days, I would often go right to the decision makers on termination, prematurely probably. I didn't want to do that here because the termination issue, the feet on the isolate, that was defense turf. Our turf was complaints about patient care, no real investigations. So we started it off with the head HR person who was able to walk, I was able to walk as an adverse witness through all the different complaints the patient made, or our client made, Maria made, and no investigation. Complaint, no investigation. Complaint, no investigation. Then the beauty of him was he actually wrote an email saying HR had concerns about the termination. So I could air out the termination through a witness that said, I have concerns about terminating. Now, he wanted to say he minimized the concerns, but it allowed me to preview the termination without really getting to it. Then the second witness, you may remember I talked about that when Michael Taylor asked me to do this case, they showed me a document that said, my client was told, UORs, the formal reports, UORs are not always necessary. So witness number 2 was the witness that said that wrote that memo. So I could get that memo out there. And the beauty of this witness was she agreed that she herself was so overworked that the job gave no quality of life, and she quit within 9 months and went somewhere that she wasn't so overworked. So it was, again, second witness, total overwork, cutting corners with staffing, right? And discouraging UORs. Then from that, we went to the president of the union who was involved in the case, in our client's case, in trying to get her job back, but more importantly, confirmed that understaffing was a chronic problem at the hospital. So you can see, we went to all of these witnesses that sold up the systemic issue. Because if you can focus first on the systemic issue, not just on your client's case, but that your client fell into this bigger systemic issue, the jury's way more willing to understand the importance of the case. So we did that, and then we went next to a nurse that was involved in this traumatic delivery where this baby was brain damaged, who herself had reported stuff and got retaliated against. So we got her out, and I'll never forget, her testimony was riveting. And right when she was done on Friday afternoon, then perfectly lined up right after that was the termination decision maker. And the termination decision maker on our client was the one who retaliated against this other nurse. So I think everybody in that courtroom believed the other nurse's testimony. And I called the decision maker, termination decision maker, went right to what the jury had just heard from the other nurse. You remember this nurse? Yeah. You deny this, you deny this, you deny this. She just denied everything that the other lady testified to. And that's how we ended Friday afternoon. So from that, we went on to some video depots of some other folks, and then transitioned into damages. So, and that's a theme. Look, in employment cases, I don't do damages early. I prove liability first. I get the jury there, and then I transition last to damages, almost always.
And in Kaiser, how did you prove up your damages? What kind of witnesses?
We had only Dr. Redding and our client.
Dr. Redding, the famous British accent.
Yeah, and Redding was terrific. And look, Maria had 30 years on this job. So, and she did not have any real treatment. She didn't have real-time treatment. It was all, but Dr. Redding did the testing, did the evaluation, and diagnosed major depression.
Do you ever voir dire on depression, since it's such a crucial aspect of almost every employment case?
It's interesting. I will say 20 years ago when I started trying these cases, if there was depression, I did. Now, I can't remember the last time. I think our society we do talk about money for emotional harm, but I don't worry about the diagnosis. I think our society has really changed in 20 years on mental health, at least in, California, on mental health issues. And I think that, I used to worry how people would feel about depression, PTSD, anxiety. I don't anymore. I think people understand mental health is catastrophic. In the Marriott case, remember, we were trying to say Dan had PTSD from the original spinal injection. It had gone into remission. What Marriott did to him re-triggered his PTSD and caused his heart to get a lot worse. We had about 200 written jury questionnaires in the Marriott case. The overwhelming majority of jurors believed there's a connection between your mental health and your physical health. That's one big difference since I started practicing. 20 years ago, that wasn't the case. Jurors get it now. They get if the mind is messed up, it affects the body and vice versa. And that, in Dan's case, pain, his chronic pain condition, is synergistic and negative in a negative way with the mental health issues. They all feed off of each other. So I don't worry about voir direing on it much anymore. I worry more about how jurors feel about money for emotional harm.
Got it. Got it. And before we talk about, well, cross-examination, is there much cross-examination of the defense's cases? Because it seems like you're calling almost all of their witnesses, except perhaps maybe they have an expert or two. Other than that, like in this, go ahead.
90% of it we do in our case in chief.
Right.
Now, I will say nowadays I've gotten different. I don't call everybody. I strategically try to leave some people to be their problem. In this case, in Kaiser case, one good example, they had the local CEO who was in charge of all the local hospitals as their client rep. He was part of the decision making. I was going to call him in our case, but I'm there for the 2 weeks with the guy. I'm watching him. He was a good witness, probably. He was a nice guy. So I let them call him in their case strategically rather than why am I bringing him on? In this case, we had 16 hours per side to try the case. Why am I spending a minute doing that initial exam rather than just letting them spend their time? So they brought him on to just say how bad what our client did was. And I'll never forget, I asked him, so, sir, you've sat there this whole time. You've heard all these witnesses. You've heard this person say, I was so overworked, blah, blah, blah. You've seen this document that says complaints about understaffing problem. You've heard the union president testify to, 1,000, whatever it was, complaints. My question to you is, don't you agree that Kaiser Woodland Hills had a problem? And he stopped and he sat there and he said, no, this is not unusual. And I said, wait a minute. So I'll tell you, I thought this was a problem at Kaiser Woodland Hills. You're telling me what you heard in this courtroom is normal for all of Southern California, Kaiser? Yes. So a lot better, a lot worse of a problem, which is why I think, I strategically now will often not call the person sitting in the courtroom as their client rep, or I will call them as the last witness in my case.
Was there any other witnesses for the defense in the Kaiser case?
They did a couple of they did a couple of, I don't even remember what they were. They did a couple of these just witnesses to take some pot shots at your client, basically, that didn't really matter much. And then they called a forensic psychiatrist. Who was George Woods from Oakland.
And how did he perform?
So he was scary as heck, to be honest. He was a elderly, nice African-American man who was up there, and I'm watching him on direct exam be super charismatic, funny. I'm watching this jury eat him up, and I'm dying, to be honest. He looked great on direct examination. And now I came into this case after experts were deposed. Critical thing in employment cases, you always, if there's psychological testing done, you have to get the raw data and the narrative scoring report. We didn't have that in this case. In California, the entire file is supposed to be provided 3 days before the depot. So before his exam, I asked the judge, hey, judge, you didn't supply this to me or to us. Can we get it supplied? He should have. To the judges, I don't blame the judge. I asked too late. He said well, maybe before trial if you ask, but you're asking me the day of his testimony, so no thanks, too late. All right, so I get up to cross-examine him after this beautiful direct. And I say, sir, you prepared for this trial, didn't you? Yes. You looked at your whole file and you reviewed your whole file, right? Yeah. And you had to, you didn't remember all the scoring data. You had to review the narrative report, to prepare for your testimony. Yes. Well, Your Honor, under Evidence Code 771A, now that he's refreshed his recollection for those documents, I'm entitled to them. May I have them? Judge smiled. All right, you didn't get it from me before, but you got it now. I got the narrative. And sure enough, as so often happens, what he was saying about what the testing was different than the scored narrative that he got. So, for 30 minutes, then I went back and forth with him on this issue and pretty much sat down after that because it was crystal clear that his spin on the psychological testing was different than the scoring narrative report he had generated. So, and to me, that's all you need. He's done at that point. He's neutralized.
Okay, who did Marriott call, if you remember, to try to diminish the damages and prevent your victory?
Called another guy from, hang on a second. Marriott called, why am I drawing a blank?
It's all right.
Just one second, I'm pulling it up. They called Dr. Berg. Berg, Dr. Berg, I forget his last name. He used to practice in the Bay Area and he now lives in San Diego. And Berg was interesting because, and this is, the cross of Berg illustrated a different concept, which is you just got to listen and see if you can take their point and make it yours. So Berg's whole pitch to the jury was Dan Callahan's chronic pain condition was so disabling that is the primary problem of his emotional distress. And actually, he probably quit the job because the month before he quit, he had been talked to by his neurologist and pain management team about getting a spinal cord stimulator. Spinal cord stimulator, the process of which is a treatment for chronic spinal pain. The process of doing a spinal cord stimulator, implanting it, is similar to an epidural injection. So at first, the pain management folks say maybe he should have a trial of a spinal cord stimulator. To get a spinal cord stimulator, you have to go through psych clearance. The psych doctors do not clear Dan for a spinal cord stimulator because they say this is too close to home. It's too close to what happened to him in the epidural. We're afraid his PTSD is going to go crazy. So defense psych, Dr. Berg's view, Dan had false hope. And he gives this eloquent speech about how false hope is so psychologically destructive. It's the worst. Why? Because, when we have adversity, we need to see this light at the end of the tunnel. And when we see that light at the end of the tunnel, we can get through that adversity. But when that light at the end of the tunnel is closed, that door's closed on us, it's so much worse psychologically than if we never had that hope in the first place. And here, that's what happened to Dan. The spinal cord stimulator got his hopes up, learning he wouldn't be cleared for it, shattered him psychologically. That's why he quit his job, not anything Marriott did. No, it was total bullshit. But okay, so I get up to cross him and I review the false hope thing. So doctor, you would agree that false hope is as much of a cause of psychological injury as anything. It's like torture, right? Because you get your hope up, you see the light of the tunnel, you think it might be okay, and then that's ripped away from you. Yes, and that is so much worse than other kinds of psychological trauma where you don't see the how it can be better because it's the hope taken away that shatters your soul. Yes. All right, well, doctor, let's talk about January 2019 until September 2019. Wasn't one thing that was going on in that time is Dan kept asking for these accommodations and Marriott kept telling him, yes, we'll do it. We'll work with you. And basically we built up to the point that he had 8 months of false hope until, 1 month before he resigned, they told him, F you, we're not going to fix the workstation. So that false hope cross was kind of all we needed with Dr. Berg.
All right. Now we're finally to the payoff, the closing argument. But before we talk about the closing argument, I just want to let everybody know that you and I are going to do a combo boot camp. So the combo boot camp is going to be David deRubertis case framing on these different employment cases and myself helping people get up and present the stories of their cases, myself and my other, coaches at my boot camps. So that way people will know what story to tell and be able to better tell that story, which is really what it's all about, is really being able to tell the story so it connects with the jury. And so we're going to be doing that 3-day combo workshop boot camp September 27th through 29th in Vegas. And to register for that will be on the triallawyersuniversity.com website. And what I'm really stoked about that is because people get to work on their cases the whole time, and it's going to constantly get better. Not only to get experience, but then the investment in the program is a complete case cost, because that case is going to go up so much in value from the work we do on it that that the people are just going to get so much better. I'm really looking forward to that class, because I'm doing one with Michael Hill on elder abuse earlier in September. And I just really think this is the next evolution of training and coaching, is to get people with the great trial lawyers who've mastered a specific area to help them figure out, what is the story? How do we sequence the witnesses? What is the evidence we need? Because, that is such a challenge to figure that out in the trial, as the trial lawyer. There's just so much going on and so much information you have to be able to determine this is important and this isn't. Just like when you get into a case, you got to figure out, what are those points I got to prove to the jury to win my case. But let's talk about closing argument in the Marriott case.
Before we do that, just to go back, so format-wise, if for the Vegas thing that we'll do, you all will be able to send me materials about your case before. I'll review the materials, and then we'll do sessions where we work through your case, how I would frame the case, how I would sequence the witnesses and stuff. And then I'll turn you over to Dan, I will just say, look, there's a reason I'm a loyalist to Dan, and it's not because he's, the easiest guy to deal with always.
Oh, you should talk.
I know. Well, hey, I'm not talking about me.
I'm talking about you.
I'm worse. But what he's done, just this whole platform, so important. But I will tell you, like I said, when I went to that Trojan Horse seminar years ago, performance skills were not my forte. If you can learn how to do the performance skills, you can be what I'm like now, getting up and doing a 2.5-hour opening without a single piece of demonstrative evidence, because your body is demonstrative evidence. It's such an important thing. And I will say, in the employment world especially, I've never been to an employment trial college that focuses on true performance skills. We don't. We focus more on substance and not as much on performance. So I love the idea of blending the two together.
Well, I think it's going to be a game changer for so many people. But the proof will be on September 30th, whether that's the case. And to further down the road, when those people take those cases to trial, and the results they get, and the confidence they have, and the calmness that they are experiencing in the courtroom. But closing argument, putting it all together, giving the jury, the empowerment, the purpose to deliver the money. So let's talk about Marriott. Tell us how you approached that closing, and what you think the points are that you drilled home that brought back such a great result.
So, look, the basics I always do include the beginning, kind of an empowerment speech, talking about the importance of the particular laws here, disability rights, and why disability rights matter, which this San Francisco jury believed already. The core point in how I closed in Marriott was kind of two different things. Number one, there are three things. Number one, walking through the transcripts and the emails that we got out at trial that showed Marriott absolutely knew that this new workstation would destroy Dan's body, and they chose to do it anyway. And the whole beginning section of closing was that I'm going to contrast Marriott's what they knew with what they chose to do. Why? Because the focus group told us, like I worried, jurors may think this was an accident, a mistake, and carelessness. So it was so important to get this, as we had from the beginning of the trial, framed as it's not a mistake, it's not an oops, it's not an accident, it's they knew and they chose to do anyway. And what did they know? So I brought up all the testimony from the trial where they admitted, the key decision makers at the hotel admitted, the new workstation did not accommodate seated work. The new workstation should not be Mr. Callahan's workstation. That they knew that forcing him to use that workstation would actually hurt his body. And then after all that, we transitioned to, so why did they do it anyway? They did it anyway because their $150 million renovation chose the look and the experience for the guests over the safety of their employees. What did that mean? Profits over people. And then we transitioned from there, and this was one of the fun parts about the case that in our TLU Huntington Beach I'll really dive into, was why? Like where, everyone that we called to testify eventually admitted this workstation was a frickin' problem and never should have been used. So why didn't it change? And then we showed, because ultimately there were higher ups who were way higher than the people they heard in this trial who weren't going to change this workstation because it must have come down from corporate. Where were those people? And you know, in the old days, I would worry like crazy that we're not calling the actual decision makers. And here instead, we tried the absence of decision makers. And in talking to the jury, they actually said that was the most compelling point. Marriott should have brought in the people that actually made the decision to not change the workstation. And they were pissed. They never heard from them. During Marriott's case, they kept expecting to hear from them and they never did. So that was kind of and then I took all of their defenses, which were, you know, we changed this workstation. We let him do this. We let him do that. We gave him this. We gave him that. And I had a couple slides. I called those Band-Aids. Band-Aids, you know, those were Band-Aid fixes. And the one night off I had in this damn, 8 weeks up in San Francisco, I flew down to LA to take my daughter to the Taylor Swift concert. And while I fell asleep during part of that concert, and she still shows me the photos of it to embarrass me, I had an epiphany go off in my mind because I had called the renovated workstation a kill shot to Dan's ability to work in opening. And Taylor Swift has a lyric that says, "Band-Aids don't fix bullet holes." So we closed out that part of the closing with all their defenses. We gave them a map. We let them park in this place. We let them use the guest entrance, not the employee entrance. Those are Band-Aids. The kill shot I told you in opening was this new workstation. And then I paused and talked about taking my daughter to the Taylor Swift concert. And I said, one thing you don't have to be Taylor Swift to know is, and they had a slide up that said, Band-Aids don't fix bullet holes. All these defenses are Band-Aids. The new workstation was the kill shot. The Band-Aids don't fix bullet holes. And that's how we closed out the liability part. And then we transitioned to damages.
As far as damages, how did you argue damages to come up with, the five? Well, was it bifurcated? The $5 million was delivered first, and then the punitive damage phase after that.
Yes, yeah. The damages, I did this differently. I really kind of did a separate damage argument for each item. Number one, it was undisputed that they re-aggravated his PTSD. So that's part of it. Number two, they aggravated his chronic pain condition. So that. And then number three, they pushed the button on speeding up the downward spiral of the heart. So I kind of argued those three, and I did use a lot of images for that, and I argued the three of them, and then just kind of transitioned to the concept that this is unlike any employment case ever, because it's not just post-traumatic stress disorder, the worst mental disorder one can have, one he overcame and had gone into remission and they re-aggravated. It's not just the chronic pain that they had made worse and how that chronic pain and the PTSD feed off of each other in this vicious cycle. It's not just that, it's also the heart and how they all feed on. So I kind of made the point that this is unique, this is unprecedented, this is like no other employment case. Asked for, I don't remember, a huge amount of money, over 20, 30 million, I think was the ask. They ended up not giving that, but they did give 5 million, which was, again, the highest that we think ever out of that courthouse in an employment case.
And then at the same time we talk about this, though, the rebuttal of this trial. Tell us how you attack you approach the rebuttal, because you got to, what the defense is going to argue in their closing, and so it gives you an opportunity to prepare your rebuttal ahead of time. So what'd you come out swinging with in the rebuttal in this case?
The rebuttal here got a little bit more heated than I normally am, because the defense lawyers attacked me a lot personally. And it was, and I don't remember right now exactly what, but it was basically, I'm full of shit. And it was very at me. So the rebuttal here was, do I really deserve that? Or is it just anything to get off the hook? The rebuttal, a lot of it was everything I showed you in my closing argument was a transcript of testimony or a document. You didn't see anything where I'm just telling you, believe me. And then they get on up and they just start not showing you evidence, not showing you testimony, twisting and attacking me, and it was, why are they attacking me? Because if the focus can be off of what they did, you will give less. If you can blame a lawyer, you will give less. You will discount the dollars if you blame the lawyer. It was something like that. And it wasn't long. We had a time limit and I spent a lot. I think my rebuttal was like 5 minutes only in this case.
All right.
But we had a smart jury. We had a good jury. They were there.
All right. Now let's talk about Kaiser closing. Just on a side note, you told us you had a 16-hour time limit for the entire trial. That's not, from what I know of California State Court, that sounds pretty unusual.
It's in employment cases in Stanley Mosque, which is downtown LA, we're seeing more and more time limits. I wouldn't say it's the majority now, but I think the trend is more and more. So if you're going to try employment cases in downtown Los Angeles, you damn well better be ready for time limits and you damn well better know how to do it. Now, I'm lucky I've tried federal cases, so I'm used to the clock. Frankly, I like the clock. I actually believe a timed trial helps present a streamlined, more effective case as long as you have time to prepare. This one was tough because 16 hours per side, when I came into it a week or two before, made it challenging.
Got it. Okay, closing this one out. Tell us how you do it.
So closing in Gachillian, it's in the Kaiser case, it's sort of what you would expect. The beginning of and I'm just looking at my other screen at the PowerPoint. It was quality of care, patient safety, patients over profits, She spoke up for all these things. When you speak up and you report things, what's the law say? You're supposed to get an umbrella of protection over your head, and I have a slide for that. What'd she get instead? She was in the firing line, and I have a slide for that. And then we went into, after the basics, the tools for deliberating, I went into what's this all about? What's this case all about? Why are we here? We're here for one simple reason. Kaiser didn't want her to file formal reports because why? Formal reports, these UORs, make someone have to go and do an actual investigation to get to the bottom of what happened. They go to risk management sends it to the department says, do a root cause investigation. So every time there's a UOR, somebody's got to decide what's the root cause. What does that mean? They got to look under the hood. Well, Kaiser doesn't want anyone looking under the hood. Why not? Because Kaiser knows what's under the hood. Intentional choice to chronically understaff to put profits over patients. And then I just launched through all the evidence that showed that there was chronic understaffing. I went through all the times it was reported. I went through the absence of any investigations. Because again, when we show the importance of what she's reporting and we show there's not a investigation into them, but it's all swept under the rug, it's a lot easier to believe they'll retaliate against someone who keeps reporting that. So we did that part of the case first, and then we transitioned to her termination and the selective enforcement. Just reviewed all the evidence of all the other situations. I developed on the spot in one of the witness exams that when a nurse in the delivery unit fails to properly monitor the fetal heart rates and fails to document, concerning decelerations on the heart rate, or fails to call a doctor in when there's a concerning pattern on the fetal heart strips, does that nurse get fired? No, they get coached. They get talked to. So if a nurse that directly doesn't do the ABCs of, obstetrical care only gets talked to, how the hell do you fire Maria for putting her feet on the isolette when she's got a 30-year perfect record? So that was basically the structure of that closing before damages.
And how did you argue the damages in this one?
This one was heavy reliance on Dr. Redding, frankly. Maria, she did a great job on the stand, but her damage, I don't think her damage testimony alone got us there. I thought who she was as a person and the quality person the jury saw in her. And and frankly, what was unique about Maria was a Filipino American, and her family was super tight knit, and they all helped each other, and they all supported each other. And like Maria, the jury heard Maria was put through nursing school by her sister, who was a nurse, and Maria back, paid that forward by putting her sister's children through nursing school. So, we had those types of things about who she was. And it was, pretty easy to then take Dr. Redding's testimony about how bad her depression had been over these years and bring that back to who Maria was. And, 62 years old, terminated for risking patient safety at Kaiser. Your career as a nurse is over. So that was a pretty, that argument kind of made itself, I felt at times. And they gave, in Maria's case, they gave, 9 million in emotional distress, basically.
Wow, that's a hell of a result. And the rebuttal in the Kaiser case, anything memorable or
I honestly, I don't even remember.
See, it's not even memorable. It's not,
For TLU, Huntington Beach, I'll figure out if there was something memorable. But I don't. It's interesting. The way I very often believe, and maybe I'm overstating this, when I get up for rebuttal, I usually feel like the jury's like, let us go in the room. I do very, detailed original closings, and everything is there. And it's not like I'm holding stuff back other than, kind of piss off points. So I don't give hugely substantive rebuttals usually. And I just honestly, I usually have this feeling where I get up and they're like, he's talking to us again, and I feel it. And these are juries that are with us too. So I've started to try to respect that cue from them and give very streamlined rebuttals, frankly.
okay. And lastly, let's talk about this last phase because both trials had it, the punitive damages phase. What do you do to go about maximizing the damages, the punitives?
Punitive phases are simply easy and fun because if you have a big company like this, there's no real evidence. You introduce the numbers and then you argue. And to me, there's a couple of critical things about the punitive phase. One is what the defendant doesn't do. Right? They didn't bring anyone into this part of the trial to say they're sorry, to say they've learned, to say they've changed policies. Right? The defense lawyer is going to get on up and they're going to tell you, we've heard your message, but that's not evidence. Evidence is a suit showing up and coming into this courtroom and apologizing or telling you what would be done differently. They didn't do that. So that's a big part of it. And then I think, the most important other part is to talk about punishment and to get the concept out that punishment has to be felt to matter. Remember the jury selection question, $10,000 fine for speeding or carpool violation. To normal people, we're not going to speed. But to Elon Musk or Jeff Bezos, I'll take the 10,000, so frickin' what? So I bring that back out and I bring out the point of punishment has to consider that. Now I do go through the jury instruction on punitives to show every element's there, but honestly, get that out of the way. And then I bring up that I often bring up a story, which is a true story, which is that when I was kind of a bad kid when I was younger. I didn't like authority and I liked to bend the rules. And I'll never forget in kindergarten being, talking back to the teacher, and I got punished by being put in the cloakroom. The problem with that theory of punishment was the toys were in the cloakroom. So I was fine being in the cloakroom. And I never stopped getting in trouble until the year was over because the punishment didn't hurt. So I tell that story, I do the Musk, etc. And then I take all of the financial numbers of the company and I just show, look, at $50 million, that's like, I'll never forget the Edison case was something like, every day, 7 days a week, 365 days a year, they bring in $40 million every single day, 7 days a week, 365 days a year, including the weekends. So I take the financial numbers and I kind of illustrate, what does it mean? You know, I'm just, I don't have the puny slides up with me right now, but and you sort of illustrate it that way so that they see how little it will mean if it's not in a certain range. Now, I will say I vary on, do I ask for a number, do I ask for a range, or do I just give these illustrations out? And the 3 cases in the last 2 years that we've gotten to that stage, I've done it different ways. In Edison, I asked for a number, and then as I was starting to deliver it, I realized I don't think this is enough. And I pivoted to, that's a floor, you can do more. In both Marriott and Kaiser, I didn't ask for specific numbers. I gave sort of illustrative ranges, basically.
All right. Well, David, this has been a very in-depth conversation, which, I think people are going to really, because this is, believe it or not, this is the longest podcast I've ever done. But it's the most, I think there's been so much substance.
I'm always the longest-winded when I'm not on a time limit.
That's why I think I give you time limits. But and just let everybody know, if for whatever reason you can't make it to Huntington Beach to be part of the class, because I think there's, we record these master classes and put them up on TLU On Demand. It takes a couple of weeks to get it done, because I just think the information's so critical that just having it, presented one time, it doesn't do it justice. And then that way, it's basically a library for trial, because they got 12 hours from last year. This will be another 12 hours. Plus, we have the trials themselves that we're going to break down. And, we kind of went over them here, but we're going to break them down in much more detail on the webinars, so that way people get more, and at that time we'll get the, the transcripts, pleadings, and PowerPoints from you, so people can really see how you put these trials together, the nuts and bolts of them. So I think I'm super stoked for Huntington Beach. I know this is going to be our best conference ever. We got so much going on there, as far as we got over 600 people coming, which I'm stoked about. Bought out the entire hotel, so it's going to be a unique experience. We got a gaming lounge every night from 8:30 to 11 with an open bar, a DJ, and a couple ping pong tables, foosball and air hockey, and a pool table. We just got so much stuff here. Food trucks, besides 4 lecture tracks with the top trial lawyers. Hey, even your buddy's coming. How about that? Nick Rowley and Gary Dordick are coming to present for 3 hours on Saturday morning, the 8th.
I might bail out of this if that's okay.
Whatever you want. You're like, my class is going for an hour field trip over to see my buddies Gary and Nick. Yeah. If nobody minds, okay? So it's going to have so many things for everybody. I'm really looking forward to it. I'm glad you can be a part of it again this year. And I'll see you in Huntington Beach.
Thank you, Dan, and I cannot wait. And thank you for everything you have done to keep letting all of us learn from each other.
And I think you're going to see too that, and also you're going to be hosting a couple of our friends on Friday, I think on Thursday afternoon. You hopefully will get there in time. George and Drew Ryan on their employment verdict that they got. That was a pretty great result for them. And that way, get a little stage time besides on the masterclass. So that's going to be great too. So I look forward to seeing you next week. Thanks for hopping by today and giving so many people the benefit of your years of experience. And, it's great I've known you all these years. I never knew how you got started. You might be like Michael J. Fox walking around with a little briefcase when you're 13 years old, and a coat and tie. I'm going to be a lawyer. But that's how it happens, the idea. So thanks, David. Take care.
All right. Thank you, Dan. Take it easy.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University. Produced and powered by LawPods.